On the record in the Simpson matter, Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Blazier, Mr. Scheck, Mr. Neufeld, people represented by Mr. Harmon and Ms. Clark. Jury is not present. We previously had scheduled a hearing with the Los Angeles City Attorney regarding certain records held by the Los Angeles Police Department Internal Affairs Division, and I've conferred with counsel in chambers, and we have agreed to complete the testimony of Professor Terrence Speed before we proceed to that argument to allow Mr. Ullman to join us for the purposes of that argument. Is that correct, Mr. Cochran?
Yes, sir.
All right. Ms. Clark? All right. Anything else before we resume with Dr. Speed?
Yes, very briefly, Mr. Kelberg will be down to address the court concerning the matter of the further discovery. Dr. Baden and Wolf were both here during the testimony of Dr. Lakshmanan and took copious notes that we observed. In the package of discovery that was just delivered to us last night, there was nothing like that. And so we are asking for the court to require that those notes be turned over to us.
All right. Well, we'll take that up when Mr. Kelberg joins us.
Thank you, Your Honor.
All right. Thank you. Well, we'll get to that when we get to that. All right, Deputy McNair, let's have the jurors, please. Yeah, the record should reflect that we've been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. And Professor Speed, would you resume the witness stand, please? All right, let the record reflect that Professor Terrence Speed is again on the witness stand now to undergo cross-examination by Mr. Harmon. And Professor Speed, good morning.
Good morning, sir.
Sir, you were reminded that you were still under oath, and Mr. Harmon, you may commence with your cross-examination.
Thank you, Your Honor. Good morning, ladies and gentlemen. Professor Speed, it's true, is it not, that you have never written an article relying on any aspect of the NRC report?
That is true.
It's true, is it not, that you have never given any lecture relying on any aspect of the NRC report?
Not a very public lecture. I've given talks at UC Berkeley on this topic, in which I've made references to the report.
Okay. Professor, I have asked you whether or not you have given a lecture which relied on any aspect of the NRC report. Have you?
Yes.
And you have relied on it?
I'm sorry, if relied in the sense of quoting it and using it as my source of information? Yes.
And basing your opinion on it?
Yes.
Will you describe the relationship of the National Research Council to the National Academy of Sciences?
Well, as I understand it, the National Research Council is a separate body funded by the United States government to produce reports and I think hold symposia, and it has some affiliation with the National Academy of Sciences, but it is formally a separate organisation. I think the National Academy of Sciences plays a fairly important role in the selection of topics and the management of the NRC, but yeah, as I say, I think they're separate bodies. That's my understanding.
And the National Academy of Sciences in this country represents the elite in various fields of science. Is that true?
That is certainly true.
And the National Research Council, the body that you mentioned, do those members also represent the elite in specific areas?
Well, certainly, yeah.
Would you agree that the members of the committee that produced the report that you've quoted, DNA Technology and Forensic Science, that those members are elite?
I would agree with that.
Would you agree that they're eminent?
Well, these words have different meanings to different people, but I think it's reasonable to say that each of them is eminent in their own field, but I'm not really in a position to judge everybody because they're not all in my field. But I think it's a reasonable understanding that that would be the case.
That they're eminent?
Yeah.
Okay. And Victor McCusick, the chairman of the Committee on DNA Technology and Forensic Science, do you know who he is?
I certainly know of him, and there's no doubt he is eminent.
Quite eminent.
Quite eminent.
What other members of the committee are you personally or professionally familiar with?
Well, I certainly know Professor Mary Claire King, who up until very recently was a member of my own university. Professor David Kay from the University of Arizona. May I look at the list?
Are you mistaken that David Kay is on the first NRC committee?
Perhaps I am. Perhaps I am.
Sure. Those are the ones that you can recall right now?
I have a suspicion there's more. Certainly
Okay.
Eric Lander, Professor Eric Lander of the Whitehead Institute. I know him pretty well. And
George Sensabaugh?
of course, yeah.
Your
George
university?
Sensabaugh, colleague at the University of California, Berkeley. I know him well.
Okay, why don't you
May I?
look at the list and tell us which other members you know well.
I have met Mr. Henry Lee. Know well would not be a correct description. I've met Dr. Thomas Marr on numerous occasions and know well in a professional sense. And that would be about it. I've certainly read writings by a number of the other authors, but I think I've mentioned all of the people that I have personal acquaintance with.
Now, of the people that you have, the members with which you are personally and professionally acquainted, you consider them to be eminent,
Yes.
do you not?
Yes.
No shortcomings in their field?
Everybody has shortcomings. I mean, eminent is kind of a blanket word. Doesn't mean somebody's perfect. So eminent is just something that people have, a description that people have when they're senior and experienced. So I don't think it would be fair to say it implies they have no shortcomings.
Did you yourself make any contributions to the first report by the Committee on DNA Technology?
No, I did not.
None whatsoever?
No.
And you first became aware of these issues, I believe you mentioned, at a meeting at USC in 1990?
That's correct.
Do you recall me being there, too?
I don't actually. I'm sorry about that.
Have you yourself made any contributions to the new committee that is in progress of writing a report?
I have.
What are the nature of those contributions been?
I contributed to a letter by Professor Joel Cohen from the Rockefeller University which addressed the issue of proficiency testing to estimate error rates.
Would you agree that the report is considered on some level as a consensus report from the respective members?
Yes, I would agree with that.
Now, Professor, would you agree that, or do you feel that, and this is talking about this report, that it amazed you how its assumptions escaped the notice of all the eminent people on the NRC panel, and then in parentheses, sarcasm intended?
That does sound like a quotation from something I've written.
Can you feel that way?
On the specific issue that I was speaking of, yes.
So you don't feel that those people were eminent in certain aspects of their report?
Well, I've already said that I don't regard eminent as implying infallibility. Eminent people can make mistakes.
Who chose the quotations that Mr. Neufeld flashed up here for the jury yesterday?
Well, he had some of them, but in fact every single one of them I have indicated in my copy already as things that I agree with very strongly and would like to see come about.
When you say he, you mean Mr. Neufeld?
Yes, I'm sorry. Mr. Neufeld was aware of some of them, not all of them, but they're all ones that I had, in advance of discussing the matter with him, singled out as important.
Okay. Now, the quote that I just read to you, and I'll give you a chance to show it to you. I want to show it to counsel first. This quote is actually from a letter you wrote to Professor Weir, isn't it?
You want me to reapproach for a second, please?
Yes, with the court reporter, please.
the sidebar again, please.
Proceed. Proceed.
Okay.
Do you have a copy of that? That's your only copy, Mr. Harmon?
Absolutely.
Do you have Ms. Carswell make us a copy of this, please? All right, you got a copy? All right.
Thank you.
Proceed.
Your Honor, may this be marked as people's next in order, Your Honor?
577.
Professor Steve, I'd like you to look at People's 577 for identification. Is that the letter that you were referring to when you mentioned yesterday that Professor Weir solicited your input on an article he was writing?
Yes, that's
And those are your comments, or many of them, with respect to different areas of the article he had given to you?
Yes.
Okay, and did I accurately read the...
Could you remind me what section it is?
Sure. It's on the last page. It's your item number 11 on the third page.
Yes.
Okay. Could we put the third page of 577 up on the Elm?
All right, may I see it, please? All right, let's see council sidebar. All right, thank you, counsel. Proceed.
Professor Speed, yesterday, a series of quotes from the NRC report that I've just asked you about were flashed up on the screen, and you were asked whether or not you agreed with them. Do you recall that?
I do.
And approximately half of those comments were from Chapter 3 of the report, DNA Technology and Forensic Science, were they not?
Well, if you'd like me
Would
to
you
check,
like to check that?
I will.
Okay. Starts on page 74 through 96.
Yep. That seems about right. Yep.
Okay. And Chapter 3 was the source or the area that you made your comment in the letter to Bruce Weir that's dated September 29th, 1992, was it not?
That is correct.
Okay. And the areas from which quotes were elicited yesterday had to do with laboratory error rate. Isn't that true?
That is true.
Now, when you wrote this letter to Professor Weir in September of 1992, when you said, "It amazed me how its assumptions escaped the notice of all the eminent people on the NRC panel," parentheses, sarcasm intended, end parentheses, you were criticizing the people, whoever they were, that produced part of Chapter 3, were you not?
Objection. I was just asking you have a chance to look at the letter before you answer the question.
Yes.
Would you like to look at the letter again, Exhibit 577?
It's been pointed out to him once already.
Oh, I'm sorry.
May I point out that the assumptions I'm talking about refer to the so-called ceiling principle.
And the eminent people you were talking about with sarcasm intended were the eminent people who wrote Chapter 3, weren't they?
Yes.
Who were they?
We've just discussed the names of the people I know. Do you want me to go through the list of names again?
Did you ever discuss Chapter 3 with Mary Claire King?
No, I did not.
Did you ever discuss it with Eric Lander?
No.
Now, Professor Weir, the first case that you became involved...
Speed.
I'm sorry, Professor Speed, the first case that you became involved in was a capital case in San Francisco, People versus Briggs. Isn't that true?
That is true.
And what year did you first become involved in that case?
I believe it was 1992.
That was a capital case, wasn't it?
I believe so, yes.
Okay. And you have some extreme views about the capital or death penalty in the United States, don't you?
Objection, irrelevant.
Sustained.
May we approach on that, Your Honor?
No.
What was the other case you became involved in? You mentioned two cases yesterday.
It was a case with Contra Costa County, and I believe the defendant's name was Robert Taylor.
Okay. Did you ever testify in that case?
No.
Your CV lists 120 articles and chapters, does it not?
Yes, it does.
None deal directly with the application of statistics in forensic settings, do they?
That is correct.
Do you have a copy of your CV in front of you?
I do.
I'd like you to refer to the item that's numbered 111 on your CV, if you would.
Yes.
Okay, and would you tell the ladies and gentlemen of the jury what the role of statistics plays in that article?
I was assisting in the analysis of data that had been collected for a study on AIDS. So statistics was involved in analysis of the data.
In what way?
Well, there was a group of male homosexuals, some of whom were HIV positive at one time and not at a previous time, some of whom were HIV negative throughout the entire period, and there was this group of male homosexuals were cross-classified according to various sexual practices that they had admitted indulging in or that had taken place or they had been involved in over the period that would have related to when they might have gone from being HIV negative to HIV positive, if that was that group, or when they remain HIV negative throughout the entire period, if that was the other group.
And in what way does your contribution to that article demonstrate any connection between HIV and AIDS?
Sustained.
It's true, is it not, that of the 120 articles and chapters, you have never expressed any concerns that you seem to have expressed yesterday about the role of forensic DNA typing in the legal system? Isn't that true?
I have not written any papers in this list about that topic. That is true.
About what you talked about yesterday?
That is correct. In papers. As I said earlier, I expressed these views in a letter for the second NRC report on this same topic.
You mentioned that you have previously served on editorial boards, have you not?
That is correct.
Would you briefly describe the role of an editor and the responsibilities that are attendant to that role?
Well, I've mainly been an associate editor, not the top editor. So the associate editor's role is usually to look at papers as they come in, as they're submitted for publication, and choose referees, people who will review the papers, get the reports from the referees, synthesize them into an overall report on the paper, which is then transmitted to the editor with a recommendation for the treatment of that paper.
And do you take that role very seriously?
Of course.
Why is that?
Well, it's one of my professional responsibilities.
And what would happen if something fell through the cracks, a published article fell through the cracks without your careful review?
I don't understand what you mean by fall through the cracks.
If you hadn't carefully reviewed something and then an article emerged in the peer review literature with your name on it as an editor.
Well, usually articles don't appear in the literature that I'm associated with my name on as an editor, but I'm afraid I still don't understand what you mean.
Okay. If you were not careful in your review of an article and the article were published, what are the consequences of the implications of an article with faulty scientific data in it appearing in the peer review literature?
Well, usually if an article appears in the peer review literature, it is regarded as the responsibility of the author. The editors may be unhappy that they let it slip through, but ultimately authors are responsible for their publications. And if there are errors, that responsibility goes home to the person that made those errors, though it may cast some doubt on the quality of the reviewing process.
When were you first contacted to be associated with the defense in this case?
September 1994.
And when did you first meet with any defense counsel in this case?
I think a month or two after that, they visited Berkeley and we talked.
Who did you meet with?
Mr. Scheck and Mr. Neufeld made the initial visit to Berkeley to talk with me.
And did you make any notes of that event?
No.
Have you? And when was the next time that you met with the defense in this case?
I think about April this year. Either I was briefly in Los Angeles, or and they, not Mr. Scheck on this occasion, Mr. Neufeld came to Berkeley. Those two communications occurred rather close together. One of them was when I was here, and the other was when Mr. Scheck and, Mr. Neufeld and Mr. Thompson came to Berkeley.
Did you do any work whatsoever between September and April on this case?
I did lots of work, yeah. Work in the sense of reading and thinking and so on.
Okay, and are those things that you would have done regardless of this case?
This case has given me an opportunity to get much more deeply into the issues than I might have otherwise. There's no doubt about that. So I couldn't say that I would have done it had the case not been around, no.
Now, you wrote no report. Is that true?
That is correct.
You made no notes of any of the sessions that you had with defense counsel in this case. Is that true?
I have written things. They're not notes of sessions and they're not reports, but I have written brief memos way back, before Christmas.
And what do those memos consist of?
Well, they were being prepared. At the time, I thought I was being involved in a Kelly Fry hearing, and I prepared a rather small number of notes on what I considered important issues, the usual sort of thing, the product rule, that just 2 or 3 of the contentious areas which I think, well, you would be familiar with. If you'd like me to enumerate them, I'll try to remember.
That's okay. Now, you knew before you testified yesterday that I would be cross-examining you. Is that true?
Not really, no.
Okay. Did you receive a letter from me?
You mean in the last 2 weeks?
Mm-hmm.
Yes,
Did you receive 2 letters from me?
I did.
And the first letter, I asked for an opportunity to meet with you about your views. Isn't that true?
That is true.
And I had advised you that I had no idea what you were going to testify about. Isn't that true?
That is true.
And I wanted an opportunity to sit down and talk with you ahead of time. Isn't that true?
That's what you said in your fax.
And did you believe that?
Oh, I believed it.
That I wanted to find out what you had to say?
Yes.
Okay. And you were in town during that week, in this town?
I was
Isn't
in
that
this
true?
town.
And you faxed me a cordial response declining the opportunity to talk to me. Isn't that true?
That is true.
And then I faxed you a second letter. Isn't that true?
That is true.
And describe the nature of your relationship with Professor Weir.
Well, he's obviously a professional colleague who works in the area of statistics and genetics, and that is not a very large field. So we cross paths, not terribly often, but from time to time. I regard him as a friend as well. I've visited him and stayed in his home in North Carolina.
So he's a personal friend?
Yeah, I wouldn't say a close personal friend, but definitely a personal friend.
Professionally, you respect him?
Certainly.
You disagree with him sometimes?
Absolutely.
Okay. Now, in the second letter, I proposed that you discuss whatever you would testify about with Professor Weir, didn't I?
You did.
And you never responded to that letter or acknowledged that letter. Isn't that true?
No, that's not true.
You did?
I did.
You responded to it.
I responded.
And where did that response go to?
It was faxed to the number you get when you ring the address that you had on your letter, and I brought a copy of the acknowledgement that the fax was sent to that place.
And what did you say in your response?
Could I perhaps look at a copy to remind me?
I never got it, so I
No,
can't.
but I do have copies here.
Sure.
Would it be possible for me to ask Mr. Neufeld to give me a copy?
Approach each person.
Shall I read my reply?
Sure.
It went to the Los Angeles County District Attorney's Office, Bureau of Central Operations, Special Trials. That's the fax number I got when I phoned, because the previous fax number didn't work for some reason. Dear Mr. Harmon, thank you for your fax dated July 27th, 1995, requesting that I discuss my anticipated testimony with Dr. Bruce Weir. With respect, I decline. Yours sincerely, Terry Speed.
Now, knowing that you're a personal friend of Dr. Weir and knowing you have professional respect for him, why did you decline to talk to him so that we might know what you would testify about in advance?
Well, the reason was that I would have felt very uncomfortable because I know that my testimony would have been disagreeing publicly with positions he's held publicly. For example, reading out a quote that you heard me attest to that I disagreed with of Dr. Weir, that sort of thing. Honestly, don't feel very comfortable chatting on the phone with a professional colleague just before I'm about to go into this sort of situation and disagree with him. I would have thought that is not a very unusual human reaction.
Now, this is the man who invited your comments on his review article, Professor Weir,
Yes?
and you felt uncomfortable speaking to him 3,000 miles away on the phone.
Yes.
Okay. Now, you criticized yesterday Professor Weir's calculations for assuming that there was no error in the tests. Do you recall that?
I'm sorry,
You criticized Professor Weir's population frequency calculations simply because they assumed that there was no error in the testing methods. Do you recall that yesterday?
May I clarify what I said?
Well, did you say that yesterday?
No, I did not say that.
What did you say yesterday?
I said that I thought the assumption is inappropriate in this context. I made no reference that I was aware of to the actual figures. I was criticising the assumption because it seems to me an improper assumption to make in this context when there clearly is a possibility of lab error and other kinds of error. That anything predicated on the assumption there is not seems to me to be suspect.
Now, your views on the role of assumptions in statistics are far from mainstream, and you have found that many times with census adjustment reactor safety, haven't you?
Objection, irrelevant and argumentative.
Sustained. Rephrase the question.
Professor Speed, is it true that your views on the role of assumptions in statistics are far from mainstream?
Objection, vague as to assumptions and statistics.
Overruled.
That is a correct statement that I put in my letter to Professor Weir. Yes, I certainly feel that not enough attention is paid to the role of assumptions in doing statistical calculations and in particular evaluating probabilities such as associated with nuclear reactors, evaluating probabilities such as those associated with incorrectly concluding that a given individual is the source of a stain.
Well,
Assumptions are critical in my view, and that's why I said that.
and you admit that your views on assumptions are not mainstream, right?
That is what I said in the letter.
Well, have they become mainstream since 1992?
In this particular context, I've become more convinced that I have broad support. I was prevented from mentioning names yesterday of many eminent statisticians
I
who
move
agree
to
with
strike
me.
that, Your Honor. That's not
It is
responsive.
non-responsive.
Could you repeat the question, please?
I will ask a question, Professor. Let's go back to what Professor Weir did when he presented his population frequency calculations to this jury, okay? How else could the jury appreciate the significance of a genetic match if they decided that no error was in fact performed?
Well, in that case, Professor Weir's calculation would probably be the most relevant thing.
And the quote from page 88 of the National Research Council report prohibits combining the population frequency estimate and the laboratory error rate. Isn't that true?
That is true.
Now, assumptions do play a role in all sorts of statistical endeavors, don't they?
Of course, yes.
Let me give you an example. You know the kind of map, I think it's called the Mercator projection map, that takes the world as a globe and flattens it out? I think that's the right term for it.
Well, there are a number of such projections.
Okay.
Yeah.
So if I said to you, Professor Speed, assume the Earth was flat, as one of these maps represent, and I was in Chicago, and I could walk westbound directly, you could tell me how long it would take me to fall off the edge if I walked westbound at 5 miles an hour, couldn't you?
Well, I think if it was made a little more precisely, I probably could. Yeah.
Okay.
I'm not quite sure I'm following
Sure.
exactly.
And the assumption that's wrong is the Earth isn't flat.
Yes, that's...
But if I forced you to make that assumption, you could do that sort of calculation, couldn't you?
I could, yes.
Can we see People's Exhibit 564, the testing, or could you get that 564? That's the note. Don't put it up here. Now, you have not spent any time reviewing the Los Angeles Police Department files on this case, have you?
I've spent a little time, but as you would know, that is outside my area of expertise, so I haven't made any attempt to master it completely.
But you were here for Dr. Gertie's testimony,
Yes?
okay, and you heard him discuss the possibilities that cross-contamination might have occurred in various places.
I did.
And were you here for the demonstration which showed on People's Exhibit 564, which demonstrated the history of samples 48, 50, and 52, the replicate testing demonstration?
May I consult my little crib sheet to see
Sure.
what those samples are?
Sure.
You can see if the
Oh.
witness is
No,
familiar with it.
Counselor, he gets to conduct his examination the way he wants to.
These are Bundy walk drops, am I right? I wasn't actually here for that, but I am... No.
Now, you don't know whether any error actually occurred with the handling of those samples, do you?
I certainly don't, no.
If you knew, if you were able to trace the history of those samples, you would be able to try to troubleshoot the likelihood that those samples might have gotten cross-contaminated, wouldn't you?
Well, that wouldn't be my job. That would be a job for a microbiologist.
Well, you mentioned common mode failure yesterday. Do you recall that?
I did, yes.
Okay, in common mode failure, somebody traced the electrical system to find out that all three of these systems were wired through the same box.
They did that after the fire.
They did that after. Could you just define that common mode failure again, please?
Well, it's used in a context where two or more systems can be, in the reliability context, can fail as a result of some common cause, even though, and it's usually used in a context where beyond that common cause, they're actually operating independently, so that the only real common connection between them is this initial one.
It's a bottleneck they all go through.
Well, you could say that
It's one way of describing it.
one way.
And do you know whether, have you evaluated the flow of samples in this case to determine whether there are bottlenecks or common modes in the handling of any of the samples?
Well, I've looked at it closely enough to see the possibility, but as I say, evaluating them in a professional sense is outside my area of expertise.
In a statistical sense,
Yes.
you could.
Well, when you know enough about a process to see that things which might initially be together then get split and have an independent existence or an independent processing thereafter, I mean, I've seen this situation often enough to know that the probabilities get reduced if there's consistency in the later analyses, but that the possibilities of some, in this case we're talking contamination occurring at the earlier stages before they were split, is an instance of this common mode that I've been talking about. So I've seen enough without being an expert to see the possibility.
What have you seen?
Well, information about some of the, if you like, life histories of some of these samples.
Well, tell us about 48, 50, and 52 then.
I'm afraid I don't have a detailed recollection of any of these. I've just seen enough to see the possibility.
Well, what have you seen that's enough to describe the possibility of those samples suffering from common mode failure?
Well, simply listening to Dr. Gertie's testimony is enough to see the possibility of something happening at the beginning before things part ways. That's enough for me. I don't have to, at least from my point of view, to recognise this possibility. I don't have to read LAPD files or understand the testimony, as far as I'm concerned.
So Let me get it clear what you heard of Dr. Gerde's testimony. You heard his direct examination. Is that true?
Some of it.
Did he directly address whether common mode failure or anything analogous like that might have occurred with 48, 50, and 52, specifically?
I don't recall that, but he may have. I don't claim to have followed every detail of the testimony.
But whatever he said was enough for you to recognize the possibility. Is that
No,
what you're...
I'm not making statements specific to items 49, 50, and 52. I was talking about processes in general, and I think I know enough about processes in general to see that there are initial phases where things might be together, and then later phases where they're being treated independently, and that the behaviour of errors and the overall probability of an inconsistency has to respect that sort of temporal and spatial flow. That's about the level at which I'm testifying, not in detail about particular drops or particular samples.
So that temporal and spatial flow that you've perceived through Dr. Gerde's testimony, that in fact does not relate to any specific item of evidence in this case, does it?
No, it's not. I'm not standing up here testifying to probabilities relating to items of evidence specifically. No.
Could we see 564?
You see that clearly, Doctor?
Would you- Sure. Just get familiar with that. Are you familiar enough with what's shown there?
Well, if I can refer back to it if you ask me a
Sure.
question about it.
Sure. I want you to assume that all three of those samples, which you know from the Bundy walkway, were typed by the three different laboratories in this case, the Los Angeles Police Department, the California Department of Justice DNA Lab, and Cellmark, and that they all produced the same DQ alpha results. Okay?
Right?
And in your jargon, the common mode failure where these samples seem to have diverged would be on June 14th in the evidence processing room. Isn't that true?
That is true.
And if those samples were all produced the same type, that suggests that if there was common mode failure, it had to have happened on June 13th or June 14th.
I'm sorry, objection to the way you said 13th, then 13th or 14th, and ask me to rephrase the question.
Rephrase the question.
That if there was common mode failure, it would have had to have happened on June 14th when they were all together for the last time.
Objection, I think that misstates the evidence.
I'm not making statements with that degree of specificity. In particular, it would seem to me I would need to be a microbiologist or somebody very knowledgeable in this to say when errors occur. All I was speaking to was the possibility of errors in that initial phase before they were split being analogous to common cause errors, and if you wanted to get the overall probability of the final consistent results being erroneous results, then you would have to consider that step in the process.
To put it, I'm sorry, go ahead.
Well, I'm certainly not saying that that is the only way in which an error could have affected all of them. But it is a way, as I think should be clear from the flowchart.
Well, if no error was made on June 14th in the sampling in the evidence processing room or on June 13th in the evidence processing room, then there is no reason to believe that the results produced by those three labs are incorrect. Isn't that true?
I can't agree with that statement.
What reason do you have to believe that based on the chronology of those samples?
Again, I'm afraid I have to be general. You said there is no reason to believe. nuclear reactors have done very bad things because people had no reason to believe that whatever malfunction actually happened might have happened. In other words, the fact that you have no reason to believe it doesn't actually mean it is true. I'm not here testifying that it is impossible or that it is necessary that errors may or may not happen in some places. We're talking about probabilities, about chances of errors occurring. And they exist, regardless of whether in any particular instance somebody may have no reason to believe they occurred. The chance of errors is something which is ever present in this sort of human activity.
You could walk out the street and get hit by a car crossing the street, couldn't you?
I believe that's a possibility.
Do you have a reason to believe that's going to happen?
Sustained.
What significance do you attribute to the fact that given the flow of those samples, each of the 3 labs produced the same result?
Well, that suggests, but again, this is an area of professional expertise beyond mine, as I speak to statistics and probability, whereas you're talking now about interpretation of results. But it would suggest that what went out was the same. I mean, an error calculation which only considered errors in the individual labs and there was a consistent result would suggest that they received the same thing. It would certainly tell you nothing about errors that might or might not have occurred before they were sent out.
Professor Speed, in fact, there are many other biological samples in this case that did not go through the June 13th and June 14th, let's call it common mode, aren't there?
Objection, Your Honor, the scope of the expertise.
Sustained.
Professor Speed, you don't know whether or not there are many other biological samples that did not have the same history of samples 48, 50, and 52 on June 13th and 14th, do you?
Or will.
May I just say that I was here when this was presented.
Objection, it's non-responsive, Your Honor.
Sustained. We asked the question.
Professor Speed, you do not know whether or not there are many other biological samples that did not go through the evidence processing room on June 13th and June 14th, do you?
No, not in detail. No.
Do you know anything about samples 303, 304, and 305?
I know what they are. I don't have an immediate recollection of their processing history.
Okay. Well, let's show you People's Exhibit 565. And if you would.
Do you have a photo that's hard to read from the monitor? Do you have an additional photocopy for Professor Speed?
I think so.
Let me see if I can get you actually a hard copy of that. If I could. Be quick if we just took that and photocopied it. Mrs. Robertson, do you have Ms. Carswell make real quick photocopy of that, please?
copy of Exhibit 565. Did you see that the other day with Dr. Gerdes?
Yes, I did.
Now, in fact, those samples, if the dates are correct, have a totally different history than samples 48, 50, and 52, do they not?
They certainly do.
And if they have a different history, then they share no common mode with 48, 50, and 52, do they?
With those samples, certainly, it would appear not. Yeah.
And would it be helpful in assessing whether common mode failure occurred in trying to track the history of specific samples in this case?
Yeah, I certainly believe so.
You didn't do that.
I wasn't doing any analyses, as you know, of the specific situations in this case. I was speaking in general.
Now, did you say yesterday that Professor Weir rejects the notion of error rate?
I believe I said yes to a quote from his testimony.
Excuse me?
I believe I said yes to a quote from his testimony which used that phrase.
Okay, and that is in fact part of the testimony that he presented, is it not?
That's my recollection.
And is this one of the reasons you didn't want to talk to him on the phone, because you didn't want to discuss this with him?
Well, as I said,
Objection, Your Honor, argumentative.
well, I really didn't want to enter into discussions about things on which I was about to testify, where I would be... I don't really have much to add to what I said before, except that I'm repeating myself. Publicly disagreeing with his point of view makes me feel slightly uncomfortable. I would rather have done it in an informal interchange well in advance of this situation, and suddenly, a few days before I'm about to stand up and testify, it's not a situation I relished. And I took your statement that it wasn't necessary that I do this at its face value and declined.
Well, why didn't you do it months ago then?
Well, you know, we have busy lives. I've been in Australia a bit. I had a very busy semester, and I don't know where Bruce has been other than here. But, you know, we haven't been having regular informal exchange on these matters since the trial began. And, well, it doesn't seem to me too surprising, but perhaps we should have.
In retrospect, you think maybe you should have?
I'm really saying perhaps some other people feel we should have.
Okay, now, in fact, if one were to... Did you call that out of his testimony yourself, or did somebody present that snippet of his testimony to you to comment on?
I had read the testimony, and obviously I was very interested in Bruce's views on something that I was testifying about. It wasn't my suggestion that we actually state it, though it was something that I preferred to do rather than have it done some other way.
And do you mean to imply that Professor Weir does not recognize the possibility of error?
I didn't mean to imply that.
Do you mean to imply that he rejects the notion that one might consider laboratory error rate?
It's my impression that Dr. Weir does not accord laboratory error rate the importance that I do, and that seemed a fairly clear statement of it. And I haven't actually seen him write anything that is fundamentally contradictory to that statement. So that seemed to be his view.
So you disagree with him on the significance that should be accorded to a laboratory error rate. Is that what you've just said?
Oh, very much so.
And not that there could be a laboratory error?
He has not said specifically that laboratory errors are impossible, yet he has, to my knowledge, never said they should play a role in the statistics of assessing the chance of incorrectly concluding somebody is the source of a DNA sample.
Okay, I'd like you to actually look at the broader, and I'd like to show you pages 33733 and 33734 of Professor Weir's testimony. Okay. Could I have that back? Does that help refresh your recollection about the full passage that Professor Weir made those statements in?
Yes, but I'd certainly appreciate a copy if you want to question me more about it.
I wish I had a Xerox machine here, and I'd give you one.
Well, counsel, I'll tell you what.
Okay.
Well, let's take a recess. All right, ladies and gentlemen, we're going to take our mid-morning recess. Please remember all my admonitions to you. Dr. Speed, you may step down. You're ordered to return in 15 minutes. All right, we'll take 15. Simpson matter, all parties are again present. Anything we need to take up before we conclude with Dr. Speed? All right, let's have the jury, please. All right, Dr. Speed, would you resume the witness stand, please? All right, the record should reflect that we've been rejoined by all the members of our jury panel. Dr. Terrence Speed is again on the witness stand undergoing cross-examination by Mr. Harmon, and Mr. Harmon, you may proceed.
Thank you, Your Honor. Your Honor, may we mark the 2 pages of Professor Weir's testimony that I had shown to Professor Speed?
That would be
578? Yes, Your Honor.
578.
Professor Speed, I want to come back to where we left off with, and I blocked out a couple of pertinent passage that you referred to yesterday. Or you had a chance to read that before the break?
Yes.
Now, isn't it true that Professor Weir, at the conclusion of the series of questions and answers, his final statement on the subject of laboratory error rate with regard to the frequency estimates that he presented was, I reject the notion that the laboratory error rate, should be incorporated.
That's correct.
Is that correct?
That's what it says.
And you understand from having read Professor Weir's testimony that the only statistics that he presented in his testimony were the population frequency estimates for the biological matches in this case.
That's correct.
Is that true? And you don't take issue with Professor Weir's statement that he rejects the notion that laboratory error rate and the population frequencies should be incorporated, do you?
Objection, that's not the testimony. And there's
Overruled.
no
Overruled.
objection, that's not evidence.
Overruled.
Could you restate the question, please?
Sure. Professor Weir, in the end of that series of questions and answers, stated, did he not, I reject the notion that it should be incorporated.
Yes.
And from having read his testimony, you know that he was referring to was the laboratory error rate.
Yes.
Okay? And what it should be incorporated or should not be incorporated with was the population frequency estimate, which is the only estimate that he presented. That's what you understood that answer to mean, did you not?
Yes.
Yesterday, one of the slides that we saw was a quote from the National Research Council on page 88. Do you recall?
Yes.
And that quote was, coincidental identity, and laboratory error are different phenomena, so the two cannot and should not be combined in a single estimate. However, both should be considered. Do you recall that being up
I do indeed.
on the
Yes.
screen? You endorsed that statement yesterday from page 88 of the NRC report.
I still do.
And you agree with Professor Weir's statement that it should be incorporated, the laboratory error rate should be incorporated with the population frequency estimate. Isn't that true?
That is true.
And the reality is, Professor Weir didn't agree that you could quantify laboratory error rate. That's what he discussed in that segment, didn't he?
Objection. Seems not the testimony.
May I read the sentence that we're talking about? He says, you're asking me, in essence, to quantify something I don't think exists. So I reject the notion of an error rate.
I reject the notion that it should be incorporated.
Well, I'm sorry, he rejects the notion it should be incorporated, but the it that we're talking about, he has just previously said, doesn't exist. That's what I thought I was, that's the quote that I was agreeing to yesterday. Incorporation of something that doesn't exist seems a moot point. He is stating very clearly here, as far as I read it, you are asking me, in essence, to quantify something I don't think exists. The something in question there is error rates. So I reject the notion of error rate. I don't see how that contradicts what I was saying yesterday. I didn't go on to comment on the quote that he rejects the notion that the it that he's just said doesn't exist should be incorporated. But I think he said very clearly that he doesn't think error rate exists. That's my reading of this document.
And you read his entire testimony.
I did, yes.
And he did not acknowledge that it is possible to make errors in DNA testing. Is that your testimony?
No, he doesn't.
I'm sorry.
Excuse me. That is the curious thing. He acknowledges that errors are possible, but here, as we have just read, he rejects the notion of an error rate. He says it doesn't exist, so it can't be quantified. To me, that is a very paradoxical point of view.
Well, you haven't made any attempts to quantify it yourself, independent of his statement, have you?
I have spoken, the answer is no to that, if I may elaborate.
Well, if it's
I've
an
spoken to the importance of...
objection that's non-responsive, you know.
Ask another question.
Now, yesterday, at the very close of your direct examination, Mr. Neufeld posed to you the dilemma when one has a coincidental match where the estimate is 1 in billions. Do you recall that? The very close of your testimony yesterday.
Well, I think I know roughly what you're talking about, but I don't think you've stated it very precisely.
Okay, well, I'll do my best. And that furthermore, that there could be a match by mistake. You recall that phrase that you used, a match by mistake?
Yes.
And the numbers that you referred to were 1 in 50 to 1 in 200. Do you recall that series of questions?
I do.
And that's the very point that the NRC addresses on page 88, the quote that I just read to you about not combining laboratory error rate and chance of a match. Recall that?
Well, I recall you reading it. Yes.
And that's what was up on the screen yesterday.
That's what's up on the screen.
How many biological samples were tested in this case?
I really don't know the answer to that, but I would say in the range 50 to 100. But I'm just guessing, so I perhaps shouldn't even bother.
Objection. I would move to strike since he said he was guessing.
Well, jury can put that into appropriate context.
Well, let me give you a definition so we can go a little bit further with this question. Let's define a sample as any biological sample which undergoes the DNA testing process.
Yes?
Okay?
Mm-hmm.
And let's assume, just for a hypothetical, since I don't want you to guess about how many, that there have been 200 samples analyzed in this case, according to the definition I just gave you. Okay?
Yes?
If those numbers that you threw out yesterday, 1 in 50 and 1 in 200, were real forensic casework laboratory error rate. Are you with me so far?
I am.
Now what that means is that the chances, or that if those estimates are correct, that 196 to 199 of the results that might have been presented if 200 samples were tested were in fact the correct answers, isn't that what it means?
Well, that's one way of interpreting it, yes. I mean, I'm not sure.
Is that a correct way to interpret?
Well, error rate is a rather vague term. I think one has to address the issue you're talking about, one has to split it up into false positives and false negatives and think in terms of the samples you're referring to, not just the number of samples, but during the testing process, the number of opportunities for making a false positive, the number of opportunities for making a false negative, and then assess the expected number of each of those kinds. That would be assuming you had an estimate of the rate. I don't think it's enough just to count samples.
Okay. Well, those are your numbers, 1 in 50 to 1 in 200.
I mentioned those as the sort of numbers one sees coming from blind external proficiency tests in related areas. For example, the bone marrow program, where they do conduct these sort of tests and they get results of that order.
Okay. So one correct way to interpret the numbers that you threw out yesterday, 1 in 50 to 1 in 200, if 200 samples were tested, as I've defined samples, would be that 196 to 199 of them were the correct answers. Isn't that true?
Well, in my last answer, I just said I think it's actually important in this context to split.
Objection, Your Honor. That's non-responsive.
So the answer is not true then.
It's not true.
No.
Yesterday you said that, at the end of that series of questions, that of the two, the coincidental match of 1 in billions and the match by mistake of 1 in 50 to 1 in 200, you said the match by mistake plays a more important role. Do you recall giving that answer at the very end of your direct examination?
I do.
And when you said that that plays a more important role, weren't you violating the very caution that the NRC prescribed in 1992 when they said coincidental identity and laboratory error are different phenomena? So the two cannot and should not be combined in a single estimate. However, both should be considered. Weren't you violating that?
I don't see how. I was making a statement about the relative magnitude of the components. I wasn't combining them, and I was considering both.
Professor Speed, you have not criticized any of the frequency estimates which have been presented to this jury in this case, have you?
Objection, argumentative and beyond the scope.
Sustained beyond scope.
Professor Speed, have you criticized any of the frequency estimates which have been presented in this case?
Objection beyond the scope.
Sustained.
Professor Speed, you do not mean by any of your discussions about laboratory error and that the match by mistake plays a more important role, that if the jury decides that there was not a mistake made in any of the testing in this case, that the population frequencies are incorrect?
I haven't previously said that, but if you ask me, do I believe the population frequencies, the answer is no.
You have not criticized in your direct examination any of the population frequency estimates in this case, have you?
Objection beyond the scope of the direct
Sustained.
examination.
Sustained.
You have simply alerted the jury to consider the possibility of certain errors which may have occurred in this case. Isn't that true?
Objection, argumentative to the form of the question.
Oral.
I think the answer simply is inappropriate there. I spoke on one aspect. I have not approved or disapproved, at least I did not approve or disapprove of the frequencies in my direct examination. I didn't address them. So
Some of the possible errors that might have occurred in this case, you listed as the chance of a sample mix-up.
yes,
Remember that? You just generalized with errors in DNA testing. Do you recall that?
yes,
And then you described generally errors in all stages of handling. Do you recall that?
I do.
Now, you have relied on the evaluation and testimony of Dr. Gerdes in recognizing the possibility of sample handling cross-contamination in your case, haven't you?
Not solely, no. I also relied on that flowchart that we had up there, which I believe is a prosecution flowchart, which shows the possibility of errors before the samples are split and sent to the separate labs. And I'm just relying on my general experience that nobody can say with certainty no errors occurred in that initial phase.
You have not made any attempt to quantify the likelihood that any of those errors actually occurred in this case, have you?
That is not my role. That is the role of external blind proficiency tests. I'm simply pointing out their possibility, and in fact, I was saying there should be tests to quantify these error rates.
Professor Speed, I want to ask you, you yourself, are you saying you're not capable of quantifying the likelihood of errors having occurred in a case such as this, a complex case such as this?
Objection has been answered into the word complex.
I am not able to, on the basis of my knowledge at the moment in this specific context. I've said how I think they should. It's not possible to look at a single case and come up with error rates. They require, sorry to keep saying this, external blind proficiency tests.
And the weak part is your knowledge at the moment in deciding how to approach this problem, isn't it?
Weak in what sense?
It's deficient.
I'm not attempting to produce figures.
You have not attempted to produce
I have not
figures.
attempted to produce figures.
In fact, nothing you have said constitutes statistical evidence that any of those possible errors actually occurred. Isn't that true?
That is true.
If the jury decides that none of these possible errors actually occurred, then the only statistical information which they have to evaluate the match evidence in this case is the frequency estimates produced by Dr. Weir. Isn't that true?
Sustain.
Professor Speed, would you be willing to allow the jury to decide whether any of these possible errors actually
Sustain.
occurred?
Sustain.
Professor Speed, since you have not provided any statistical information about the possibility that any of these errors occurred, what information is left to this jury to decide the significance of the biological matches that have been presented in this case?
Objection, may we approach, Your Honor?
What I have spoken to is the way in which errors can be assessed with correct testing.
Objection, Your Honor, that's not responsive.
It is. Answer the question, Professor.
I'm sorry, could you repeat the question?
Could we?
What? I'm sorry, Are you sustaining the objection, Your Honor, or overruling it?
No, I'm directing him to answer the question.
Thank you.
Professor Speed, since you have not provided any statistical information about the possibility that any of these errors occurred, what information is left to this jury to decide the significance of the biological matches that have been presented in this case?
I thought I was starting to answer that, but I was speaking generally to the possibilities. I mentioned some figures that I know of in my experience as a statistician and in reading literature on error rates in similar biological contexts. I believe that's information that I've provided the jury. I don't understand why.
What about Dr. Weir's frequency estimates?
Excuse me, what about them?
Well, is that left for the jury to decide, since you have not presented any statistical evidence of cross-contamination or any of these errors?
Objection, argumentative and beyond his expertise.
Argumentative, rephrase the question.
Do you mean that by the generalizations that you presented to this jury that the jury should not be free to consider the population frequency estimates that were presented by Dr. Weir?
I'm not telling the jury what they should or should not consider. I was not speaking about population genetics frequencies. I have made no statement to date, except a very brief one earlier in this cross-examination, about these issues.
All right, let's wind this up.
I'm trying to, Your Honor. If the jury decides that none of those possibilities...
Counsel, rephrase that. The jury gets to decide all issues of fact in this case. They understand that.
Since the jury gets to decide whether any possible errors occurred,
Now, let's start again.
since you have presented no statistical evidence that demonstrates the likelihood that any errors which might have occurred actually occurred, the only estimate, statistical estimate, which they have to evaluate the significance of the match evidence in this case is Professor Weir's population frequency estimate. Isn't that true?
I don't believe that's a correct description of my testimony. I believe, without actually giving numbers and saying these are error rates on the basis of certain sorts of tests, I have still given them statistical information.
Given them estimates?
I have not given them numbers, but I believe my testimony has been informative.
Thank you. I have no further questions.
Mr. Neufeld?
Professor Speed, do you believe that providing Dr. Weir's frequencies without providing error rates in this case is misleading?
That was my direct testimony.
Now, Mr. Harmon asked you a couple of questions about your position on assumptions. Do you recall that?
I do.
Okay. And about certain things being mainstream or not being mainstream. Do you remember that?
That's correct, yeah.
Okay. Do you believe, sir, that your views on the necessity of relying on external blind proficiency tests to produce error rates for forensic DNA profiling is mainstream or a minority position?
I think in this situation, I'm very much in the majority. I hardly know any other statistician who's knowledgeable about statistics and DNA profiling who doesn't think that.
One moment. Now, remember when Mr. Harmon put up a picture of the Bronco stains, item 303, 304, and 305? Could you turn that on again, please? I meant the flow chart.
Yeah.
All right. And he was pointing out to you that these stains did not have the same common point of origin as did the Bundy blood drops. Do you recall that?
I do.
Now, do you see, by the way, on this sheet where it states that the blood stains for 303, 304, and 305 were actually collected on August 26, 1994?
Yep, I see that.
Now, even though they may have no common mode of error with the Bundy drops, is it conceivable from a statistical standpoint that 303, 304, and 305 may have their own common mode of error?
Sustain. Sustain.
Well-
And we're referring to People's Exhibit 565.
Yes, thank you, Your Honor. Well, it has been asserted in this case, let me ask you a hypothetical. Assume that there has been testimony that these stains had been in the car, in the Bronco, for 2 months prior to their collection. And assume that during those 2 months, there were numerous unauthorized persons entering the Bronco or had access to the Bronco.
No foundation, possible speculation.
Overruled.
If an error happened during that 2-month period, approximately 2-month period, is that the kind of error which you described earlier as a common mode of error?
Yes, no foundation, assumes facts not inevitable.
Overruled.
Now, it's stretching the definition somewhat, but it captures the essence, that it's something that is common to those samples before they received their separate analyses, which in this case I assume were consistent.
You mentioned that you haven't quantified the error rate for forensic DNA profiling. Is that correct?
That is correct.
But have you made suggestions to the appropriate bodies on how that error rate could possibly be quantified?
I have. I've written a letter to the National Research Council relating to the update or the second volume of this, and of course I've simply echoed with a little more detail the sentiments in the first one.
Finally, prosecutor asked you whether or not you had called Dr. Weir before you testified today, and you said you hadn't. And you mentioned that you had been consulting or working with, using your expertise, your time, and your effort to assist the defense or to explain things to us since September of 1994. Did Dr. Weir, prior to his taking the witness stand here, call you to discuss his positions?
No, he didn't. I think we're both a little uncomfortable about being on opposite sides in this issue.
Nothing further, thank you.
Mr. Harmon?
Just a few, Your Honor. So you think Professor Weir misled this jury about not presenting error rates?
Objection to his impression of someone else, Mr.
Overruled.
That quote that you gave me earlier, I've disagreed with it.
Objection, that's not responsive.
Overruled.
You're asking me to say, did a colleague mislead a jury? And that sounds a rather strong sort of statement, but if I've got to answer yes or no, then the answer must be yes.
Didn't you just say that to Mr. Neufeld? Did you hear the question he asked you about that?
Objection, ask and answer.
Overruled.
Sorry.
Okay. Now, this is Mr. Neufeld. Okay? And I'd like to ask you if he asked you this question about 5 minutes ago. Okay? Professor Speed, do you believe that providing Dr. Weir's frequencies without providing error rates in this case is misleading? Did you hear him ask you that?
I did.
And did you say, that was my direct testimony?
I did. And
Did
if
you mean that?
I did.
He was misleading.
All I can say is to say something is misleading is a more benign way than answering yes, this person misled the jury, which is what you asked me.
Okay.
And I was understandably uncomfortable about having it phrased in that way.
Now, in fact, this jury heard the laboratory error rates for each of the laboratories that were presented from the laboratories themselves. Isn't that true?
Objection again to this jury and objection to his misstating the testimony.
Overruled. Sit down.
When I use the term error rate, I mean...
Objection, it's not responsive, you know.
No, he can answer the question. Well, the form of that question allows this type of answer. Go ahead and answer the question, Professor.
I don't believe that the figures presented by the three bodies, if indeed all three did, are error rates in the appropriate statistical sense, because they were not evaluated on the basis of external blind proficiency tests. So my answer to that question is no. They did not present error rates to the jury. They may have presented figures to the jury, but I would not dignify those figures with the description error rates in the sense that I'm sitting here talking about this term.
And in the 10 months that you've been retained on this case, you have made absolutely no effort to calculate an error rate that would meet your satisfaction. Isn't that true?
We've already covered that.
So you disagree with the form of the proficiency test results that they have presented to this jury, each of the laboratories?
The answer is yes. The design of the study that goes into an estimate is fundamental to the meaning of that estimate.
Now, let's go back to 303, 304, and 305, if you will. Okay. Now, you had never seen or been interested in any of the information that's on that exhibit until I showed it to you today. Isn't that true?
That's not exactly true. No.
What is the truth about those items?
The truth is a little vaguer. I have a sort of patchy knowledge of quite a lot of this evidence, but I do not feel comfortable sitting here claiming to have a detailed and accurate knowledge. But it's just not true to say I've never been interested. I actually have a lot of this stuff to sort of, as it were, general background, so I know the context in which I'm thinking about these issues.
Now you allowed, in response to Mr. Neufeld's questions, that there might be something in common with all three of those samples. Is that what you said?
I believe so.
But you have no idea what it is, do you?
No, I don't.
Do you remember what the results are in those three samples?
Well, I don't remember them, no.
So you have no idea whether the possibility of this common mode failure actually existed with those three samples. Isn't that true?
In general, the answer is no. But
Okay.
that's a general situation. Usually you don't know if errors occur unless it's in a test where the truth is known.
Now, one of Dr. Gertie's contentions was that in the sample handling for the evidence that was collected at Bundy, the samples from Bundy were exposed to the defendant's reference sample. Are you aware of that?
I'm
Objection to Dr. Gertie's intentions.
Sustain, rephrase the question.
Contentions, Your Honor. I'm sorry.
Contention?
Contentions.
Rephrase the question.
Sure.
But, counsel, aren't we going
I'm almost done, Your Honor.
a little broadly here?
It's within the scope. Yes, we are. One of Dr. Gertie's contentions is that the stains from Bundy had potential exposure to Mr. Simpson's reference sample during the sample handling. You were here for that, right?
That's right, and I am aware of that.
Do you have any idea or information in this general background information that you have whether or not the same statement could be made about 303, 304, 305?
No.
Not a whit of information.
At this, sitting here, no. I believe I have some notes, but that's not relevant. Huh?
Okay, and the same question with regard to being exposed to Nicole Brown's reference sample. Not an idea at all about whether or not those three samples were exposed to her reference sample during any of the processing.
That's true.
And the same question with regard to Mr. Goldman's sample. You do not have any idea whether or not those three samples had any exposure to Mr. Goldman's reference sample. Isn't that true?
That is true.
Okay, thanks.
Nope.
Mr. Harmon asked you whether or not your requirement that the error rates be based on external blind proficiency testing was an objection you had as to the form of the testing. Do you recall that?
Could you state that again?
Okay.
An objection?
Do you remember whether, I don't mean it in a legal sense, sir. I mean, do you remember when Mr. Harmon was asking you a few minutes ago whether or not your opinion that external blind proficiency testing is a necessity, is a precondition for presenting an appropriate error rate, whether he asked you was that simply, your opinion? Remember that?
I do remember that.
Okay. Is that also something which has been strongly recommended by the National Research Council?
Certainly. It was in the quotes we read out.
Is both the necessity of external blind proficiency testing and error rates been strongly recommended by your colleagues in the statistics community?
Yes.
Thank you.
As to this witness? All right, thank you, counsel. Dr. Speed, thank you very much, sir. You are excused. All right, I think we need to discuss our next witness, correct?
Yes, I think
All right. All right, ladies and gentlemen, let me ask you to step back into the jury room for a few moments. Jury has withdrawn from the courtroom. Two matters we need to take up. We need to take up the matter with the city attorney's office and the motion in limine regarding Dr. Mullis. And you indicated to counsel that you wanted Dean Ullman to be here for the internal affairs argument. I have not seen him appear.
Yes, Your Honor. It's my understanding his plane was due here at 10:10, and we're expecting him any moment. I had Mr. Douglas to step out and check. Apparently he's not here yet, and if I may have just a second, I want to inquire about the motion in limine regarding Dr. Mullis. All right.
Because Mr. Ullman is not here yet, Your Honor, perhaps we could take up the issue of Dr. Bodden's discovery.
Well, let's
see where we are on this.
Let's see where we are here.
Opposed to the court is we need, as I indicated, the court to utilize the time over the lunch hour to make some decisions regarding order of witnesses. And what I'd like to do now is to proceed with the argument regarding Dr. Baden and Mr. Kellberg and Mr. Shapiro. By that time, I'm hopeful that Dean Ullman will be here and we can have the city attorney here. And then I would ask the court to defer
All right.
as we speak. Good.
Let me ask Mrs. Robertson then to ask Mr. Walsh. All right, he's on his way over.
All right. We can proceed if the court wants to with the Dr. Baden motion.
All right, let's start with
And then we'll
Baden.
be ready with Dr. Ullman. Then I'll ask for recess at that point, Your Honor. That's the other one.
That's fine. All right, Mr. Shapiro, are you going to handle the matter regarding Dr. Baden and Dr. Wolf?
Yes, Your
All right. Mr. Kellberg.
Good morning, Your Honor, and thank you for giving me a moment or two of your time. I was provided, our office was provided late yesterday evening under an August 8, 1995 cover letter, various notes of Dr. Baden, Dr. Wolf, Dr. Lee. And conspicuously absent from these notes is any note made by either Dr. Baden or Dr. Wolf during the time of Dr. Lakshmanan's testimony. And if the court doesn't want to take my recollection, I'm sure we have videotape available, but my recollection is both Drs. Baden and Wolf had yellow pads on which they were scribbling what appeared to me to be copious notes during the course of Dr. Lakshmanan's testimony, in particular his description of wounds and interpretation of wounds, et cetera, et cetera. This material has not been provided to us, and there is no basis on which it becomes privileged. If these are their notes, they are their notes. There is no work product privilege that applies if the witness is to be called, and in fact, in California, as the court is well aware, under Izizaga, the only work product privilege that applies is 2018C of the Code of Civil Procedure, the absolute work product, impressions of attorneys, etc. So that there is nothing in Izizaga that prevents or allows the defense to, in essence, hide those notes from us. And really, those are the crux. I'm assuming Dr. Baden's going to come in here and talk about forensic pathology. If he wants to come in here and talk about stain analysis and DNA and so forth, where the notes that he has provided us may have some relevancy, we may be having an issue as to his expertise. But if he's coming in to talk about forensic pathology, there is almost nothing in his notes other than a litany of what he saw on June 22nd at the coroner's office, actually notes of Dr. Wolf during the course of their examination. There's nothing, of course, regarding findings, interpretations, what have you. Clearly, under the Lyons case, 13 Cal 3rd 500, it's clear if he's going to be called, even if there were a work product privilege attached, it is waived by the concept of calling him. And as I said yesterday to the court, I learned to try cases when trial by ambush, when one-way discovery was the rule of the day. So I'm not going to stand here and tell this court I'm not ready to go. I'm ready to go. I could be ready to go in 30 seconds if they wanted to put him on next. But in fairness, if we're going to have reciprocal discovery, if we're going to try and avoid these ambushes, if the defense is not going to be able to hide his views from our evaluation in advance, then I must be down here and ask this court to impose the will of the people of reciprocal discovery, that they provide these materials to us. And again, I know of no legal basis, not attorney-client, because there's no confidential communication between the client and Dr. Bodden or Dr. Wolf. This is Dr. Bodden or Dr. Wolf taking notes during Dr. Lakshmanan's testimony. So it's all on work product, of which there is no work product privilege under Izizaga, and even if there were under Lyons, it is waived by their decision to call him. So I ask for those notes, any other notes that may exist, and I also ask to preview any boards or charts or diagrams that the defense intends to use during the course of Dr. Bodden and or Wolf's testimony.
Other than those that aren't already in evidence?
Correct, of course. Those are my requests, Your Honor.
All right. Mr. Shapiro.
Good morning, Your Honor, and thank you. Your Honor, I think Mr. Kelberg is well aware that on June the 14th of 1994, I retained the services of Dr. Badden, Dr. Wolf, and Dr. Lee as a consultant. And upon that retention, I notified the Los Angeles Police Department that, in my opinion, these were the leading experts in the country in their specific fields, and offered their services to both the coroner and to the crime lab at the Los Angeles Police Department to aid them in any way that could be of benefit in trying to focus on who the real killers were in this case. That request was turned down. Dr. Badden has been consulting with me on almost a daily basis since this case began, and is familiar with almost each and every aspect of the case, including evidence collection, including forensic pathology, obviously. He was the person who found the errors at the coroner's office that resulted in a report being generated of 16 mistakes and of the contusion to the brain that was missed by the coroner. He, like Dr. Lakshmanan, who in the most tedious testimony of this case over 8 days, is not a person who makes copious notes of everything he does in an overall consultation. He is a conduit between the pathology, Mr. Simpson, and myself to educate me so I can hopefully present the points of view to the jury regarding the pathology in this case, the manner and cause of death, and the circumstances surrounding that death. As the court will note, Dr. Lakshmanan testified he spent 200 hours in preparation, yet he had not a single note. So I don't find it surprising that Mr. Kelberg would be unaware. I find it surprising that Mr. Kelberg now would expect that Dr. Bodden has substantial notes. Regarding whether or not the notes that were taken during the examination are discoverable, I would suggest to Your Honor that since those were done at my direction, and since both doctors were here at my request, and since they were aiding me in my presentation of cross-examination of Dr. Lakshmanan, that they are clearly privileged and are not discoverable. And they are part of the work product that I generated along with the doctors regarding this case, and purely for one purpose, for the cross-examination of Dr. Lakshmanan. So those are not discoverable. We've had 2 requests for reports, and it is my practice with consultants not to ask for reports since they have been working on this case for the last 13 or 14 months. It would be impossible to generate anything short of a book to be a comprehensive report of all the errors, mistakes, and problems that they see with this case. So there are no such reports. As far as the notes that have been taken, I've asked Mr. Blazier to review all the materials. He has done that. He has furnished that to Mr. Kelberg. Mr. Kelberg has been very candid. He's ready to proceed. So are we. They have everything that they're entitled to.
Mr. Kelberg?
Your Honor, that's, I hate to say this, a very disingenuous response. Is Mr. Shapiro saying that there are not notes that Dr. Baden and Dr. Wolf wrote that are in the possession of the defense and not provided to us? As I understand it, those notes do exist. Now they're claiming work product. Well, they didn't claim work product on the notes they sent across. And it doesn't matter whether Mr. Shapiro is the one that requested their presence here or not. 2018C is the only work product that applies in California. And of course, Mr. Shapiro can't cite any case that conflicts with the Supreme Court decision in Lines 13 Cal 3rd 500, that even under a work product arrangement, which was the old Colley civil work product application in a criminal setting when we had one-way discovery, I know the court's well aware of the case, 30 Cal 3rd, that by retaining the expert, by allowing the expert to do work on the case, there was a work product privilege that applied. But when Lines says you put that witness on the stand, you waive the work product privilege as well as attorney-client, because there the psychiatrist was evaluating the defendant, so there was confidential communication. The defense cannot stand here and say we are not entitled to those notes. I don't care what reason Mr. Shapiro had for having Drs. Wolf and Baden here. The point is, if they made notes, we're entitled to them. And by the way, Mr. Shapiro conveniently does forget that Dr. Lakshmanan provided detailed reports in Exhibits 350 and 351, identifying every injury that was observed, trying to identify every error that was found in his review of the autopsies. Apparently, Drs. Baden and Wolf were unable to do that. And the real reason, as everybody knows, is they want to ambush us. And everybody knows it's not a secret. That's the way the game is played. Is this going to be a game, or is this going to be a search for the truth? If Mr. Shapiro can give this court a citation to a controlling case from the California Supreme Court that says we're not entitled to it, let's hear it. Let's look at the case. Let's see if it in fact says what he says it will say. Let's see if Lines is overruled. It's not. I submit to the court, this is an area I've done quite a bit of review in. I'd like to think I'm pretty up to date in the subject. And I think the court will find there is no case which says Lines no longer applies in spite of Prop 115 and reciprocal discovery. We're entitled to those notes. This should not be a trial by ambush. Whether I have the skill to cross-examine him or not, right this moment, without those notes, is not the issue. What is the issue is the will of the people to see that this is a search for the truth and to get from the defense the notes that they have. I'll submit it, Your Honor.
All right. Thank you, counsel. All right. I'm going to direct the defense to turn over Dr. Baden and Dr. Wolf's notes if they are to be called as witnesses. All right. Tomorrow?
Now, I understand Dr. Baden is going to be possibly on the stand tomorrow morning.
No later than tomorrow.
Will I have an opportunity at least to
Yes, you will.
thumb through them?
Yes, you will.
Thank you, Your Honor.
You're welcome. All right. Let's see. Mr. Walsh hasn't made it yet. How about the Mullis issue?
On that issue, I think we indicated before we take this issue, we want to, that will be the subject of some discussions for the lunch hour.
All right. Then we'll await Mr. Walsh to arrive with regard to the IAD issues.
We'll proceed with that.
All right. And let's see, one other matter. Let me see Ms. Clark and Mr. Cochran.
I also requested to see any exhibits that they would use that were not already marked. Does the court order include that opportunity?
That'll be first thing tomorrow morning.
Thank you, Your Honor.
right, thank you, counsel. We've just had a sidebar conference regarding scheduling of the various motions that we have to take up. And counsel, I'm going to suggest that we stand in recess at this time until 1:30, and then we'll start taking up the motions at that time. All right?
Excuse me, Your Honor. Mr. Shapiro, I thought wanted to put something on the record. He asked me to stay regarding photographs.
I think I can repeat that out of Mr. Kelberg.
All right.
Great. Thank you, Your Honor.
Photographs apparently taken June 16th of 1994 in Chicago that we had not received.
They have
Sent in Xerox form.
They have the Xerox. I will request that a set be prepared.
All right. All right, we'll stand in recess until 1:30. Thank you, counsel. Again, present, the jury is not present. Counsel, one of the motions that we have on calendar, actually we have two for today. We have the Stockdale motion and the IAD motion. And previously, when this matter was submitted to the court, I advised counsel and Mr. Simpson at the time that my wife was a captain with the Los Angeles Police Department at the time. And I recollect that she was at Internal Affairs when this case was assigned to me back in July of last year. At that time, she was the Captain 2 there and the chief investigator. When this matter of leaks came up, the Los Angeles Police Department conducted its investigation, and essentially Captain York was not involved in that investigation. This issue has arisen again, and since that time my wife has been promoted to the Captain 3 of Internal Affairs. And I feel that since this particular motion involves files that are there, investigation that was conducted by the Internal Affairs Division of Los Angeles Police Department, I think it's more appropriate that another judge hear this motion. And I am comfortable with the fact that my wife has had no involvement in that investigation from start to finish, and I don't feel that there is any actual conflict involved. However, I think the appearance is such that I would feel more comfortable, and I think the parties would feel more comfortable if another magistrate heard this particular motion. And I discussed this informally with counsel off the record, advised them of my inclination that I was going to transfer this to another judge, to Department 100, to the supervising judge, Judge Basque, for his assignment, so that this can be heard by a magistrate who has no spousal connection to any of the parties involved here. However, I've also informally discussed with the parties that in the event that the magistrate hearing the motion does grant an in-camera hearing, that because this court is more familiar with the issues involved, that this court would then, with the agreement of the parties and stipulation of the defendant, agree to do the in-camera hearing if that comes to pass. Is that your understanding, Mr. Darden?
That is, Your Honor.
All right, is that your understanding, Mr. Walsh?
Certainly, Your Honor.
Is that your understanding, Mr. Cochran?
Yes, it is, Your Honor, and I confer with Mr. Simpson regarding that.
All right, is this arrangement agreeable to you, Mr. Simpson?
And I should point out, Mr. Simpson does want to be present at that hearing when it's argued, Your Honor.
Yes.
And I had suggested to the court that if another magistrate wanted to come here, it would be fine, but we'll go wherever.
Well, let me ask, it's a matter of judicial protocol. I will invite Department 100 to make the assignment. Is it agreeable with you that I contact Judge Basque and ask him to make the assignment directly?
Yes, and then moving further, and I'll make a specific request, Your Honor, just from the standpoint of logistics, and we're set up here, we would like Mr. Simpson to be present for this hearing, and you have no concerns about protocol if the new magistrate would come
Just
here.
as long as they don't change all the adjustments on my chair.
Your chair. Or move your pins or your things. I understand, Your Honor. If you can work those things out, we'd be more than happy to remain here and wait for the other magistrate. And we could then, of course, in the course of argument, explain that if the magistrate believes that there should be an in-camera proceeding, we would stipulate both sides that Your Honor would conduct that because of your familiarity with the facts.
All right, then I'll take a brief recess, then I'll contact Judge Basque, ask him if he will assign the judge directly to hear the matter here. All right. All right, we'll take 5 minutes. Back on the record in the Simpson matter, counsel, I've consulted with Judge Basque in Department 100. He has agreed that for logistical reasons that he will assign the matter to Department 123, which will be heard here in Department 103 forthwith. So as soon as Judge Reed arrives, the matter will be heard. So I will excuse myself, and Judge Reed will take the bench to hear the motion. All right, we'll stand at recess until Judge Reed arrives. Thank you, Judge. Yes, sure.
All right, good afternoon. Needless to say, I am not at all familiar with the proceedings which I will now preside over, but for I have read and considered a defendant's motion for statements given a witness in the course of an internal affairs investigation filed August 1st, and a motion by the city attorney on behalf of the Los Angeles Police Department to quash defendant's motion, to quash the defendant's subpoena ducis tecum, which I have not seen. So other than that, I have read and considered nothing. Who on behalf of Mr. Simpson will be addressing the issues before this judge? All right, thank you, Mr. Ullman. And on behalf of the police department?
Arthur Walsh, Assistant City Attorney, Your Honor. Would you like me to give the court a copy of the subpoena ducis tecum at this point?
That would be helpful. And as that's being given to me, Mr. Ullman, in your motion filed August the 1st, it appears not to be in response to the SDT, but rather a request for discovery?
Yes, Your Honor. I believe the subpoena has actually been mooted. We believe we're entitled to this in the course of discovery in this case, and that a subpoena is not actually necessary, since what we are proceeding with is not a pitches motion, and I'll explain that at greater length, Your Honor.
No, I agree with you. That was my interpretation.
I think it's important at the outset that we get past any question of label. This is not a pitches motion. We are not seeking the personnel records of any specified police officer to show previous citizen complaints against that officer. What we are seeking is an investigative report that was done in connection with this very case to investigate issues raised by this case. And we believe that when witnesses are going to be called in this case to testify about those same events, that we are entitled, as a matter of course, to the statements that they made in the course of that investigation. I think the closest analogy that we have seen previously in this case is the investigation that was conducted on behalf of the police commission by Detective Muldorfer with respect to the events that took place at Vertel's garage with regard to the Bronco. Here we had a separate internal investigation by the police department in which Detective Muldorfer went to the garage and interviewed a number of witnesses who became material witnesses in this very case with respect to the same events, with respect to the chain of custody of the Bronco automobile. And of course that report was at that time produced and made available, and the previous statements that those witnesses had made to Detective Muldorfer were then available to both sides to confront and cross-examine and examine these witnesses with respect to those same events. Here, it's really just a matter of fortuity that this investigation was assigned to internal affairs. And simply by the administrative machinery of putting internal affairs in charge of this investigation, that does not insulate it from any discovery in a criminal case. The privilege that's created by Penal Code Section 832.5 with respect to personnel records is a qualified privilege for personnel records. It is not a qualified privilege for internal affairs investigations. And if those internal affairs investigations relate directly to the ongoing disputes raised in the context of a criminal trial, we believe that those reports and the interviews of the witnesses involved should be available to both sides so that they can properly litigate the issues that are raised in this case. Now, this is not a fishing expedition. We're not looking for an internal affairs report so that we can fish through it and see whatever we might find that may be helpful.
Well, let me stop you for my clarity. Your request is for statements made during this investigation.
Precisely.
It is limited merely to statements of potential witnesses or witnesses that will testify in this case.
That is correct. We are not seeking conclusions. We are not seeking recommendations. We are not seeking any personnel action recommended with respect to any particular officer. We are looking for the statements of witnesses because those witnesses are material in this trial with respect to the same issues that were being investigated by internal affairs. We're talking about witnesses who will testify in this trial before the jury, notably Michelle Kessler, who is the director of the laboratory, then Commander, now Deputy Chief David Gascon, and their testimony will relate directly to the subject of the investigation by internal affairs, that is, leaks to the press, and also Mr. Matheson. So we believe that these statements...
Who is Mr. Matheson?
Mr. Matheson is a deputy director of the laboratory. And all of these people were, of course, the focus of the internal affairs investigation into where the leaks were coming from of testing results in the course of the investigation and preparation for trial of this case. The issue is also relevant in the context of the... Oh, I'm sorry. I've just been reminded that Aaron Riley and Colin Yamauchi, who are also employees of the laboratory, may have been interviewed in the course of this investigation. This investigation is also relevant in the context of the pending matter before Judge Ito with respect to piercing the shield law, because one of the factors that the court is required to look at in determining whether the newsman's or newsperson's shield law should be pierced is whether there are alternative sources available to get the same information. And to the extent that these witnesses were interviewed with respect to their knowledge of leaks, we do have the exhaustion of an alternative source which may be a very compelling argument in favor of piercing the newsperson's shield law, because now we are left with only the newspersons as the source of information about where these leaks came from. And finally, they're relevant in terms of any potential exculpatory material, because the question of leaks has become a substantive issue in the context of this trial. We believe that any information that reveals the possibility of leaks within the Los Angeles Police Department may be exculpatory evidence that the defendant is entitled to under Brady versus Maryland. So for all of these reasons, we
Well,
believe...
what type of, I mean, unless you have some theory of an exculpatory statement, then in that sense, it would be a fishing expedition. What are you looking specifically for?
We are looking specifically for information as to who had access to the information that was leaked, when they had it. We believe that the investigation may disclose a chain of events that points a inference or a circumstantial a suggestion with respect to particular individuals who may have been the source of the leak. And we believe that that would come within the Brady rule in terms of being potentially exculpatory evidence to show that, in fact, these leaks did come from the Los Angeles Police Department. Now, for all of these reasons, the report, we believe, is relevant to issues that we are litigating in this trial. But we're not even asking that the report simply be turned over to the defense. All that we're asking is that Judge Ito be allowed to conduct an in-camera inspection of the report to see whether there is relevant and material evidence that should be made available to the defense contained within that report. And under Section 915 of the Evidence Code, whatever privileged information may be in that report can continue to be protected. And again, I emphasize that we're not asking for privileged personnel files. We are asking for actual witness statements that are a result of this investigation. Even the shield of personnel records, however, is not an impenetrable shield. Like any other shield...
But we're not talking about personal
Well,
records.
we're not. But
I don't want to get off into something that is not pertaining to your request.
All I want to emphasize, Your Honor, is that the bottom line here is the defendant's right to a fair trial and accommodating that right while still respecting whatever privileges may pertain with respect to any of this information. And we believe that this issue is such an important issue to be litigated in this trial that to withhold from the defense an investigation conducted by the Los Angeles Police Department into the very allegations and issues that we are litigating involving interviews of the very same witnesses whom we are calling as witnesses in this trial gives us a right of access to those interviews. Could I have just a moment?
Yes.
I realize I have been making an assumption that Your Honor is fully familiar with the relevance and materiality of the leaking issue in this case, and perhaps I should take a moment to make sure that Your Honor is aware of the context in which this issue arises.
Okay, be somewhat brief. I believe that I am. I understand what you're asking for and the reasons you're asking for it. My concern is apparently you interchange the report, assuming there is a report, with any statements made by one of these 4 or 5 witnesses or potential witnesses. And my concern is, or at least my understanding of your request, is only previous statements, if they were made by one of these 5 people to the LAPD Internal Affairs in regards to the issue which you present, and that is the leaking of information to the press.
Well, let me clarify that, Your Honor. We believe the entire report should be turned over to Judge Ito for an in-camera inspection. We don't claim that we're entitled to see the entire report. Judge Ito can then glean from the report whether there are specific witness statements that relate to witnesses that are relevant to these proceedings, and at the same time, he can ascertain whether there is Brady material contained in the report. I don't know that. I'm kind of flying blind, but we would like the in-camera inspection to address both of those issues. And we believe it could also inform Judge Ito's resolution of the newsperson's shield law as well, in terms of providing him with a factual basis for a finding that there is no reasonable alternative to piercing the newsperson's shield law. So we think it's relevant for all of those purposes, but we recognize that we're entitled, at least initially, to the witness statements, and beyond that, we will rely on the in-camera inspection. Now, the relevance of the leak, of course, is the fact that this leak occurred before DNA results had been obtained, and in the case of one leak, the leak occurred very shortly after DNA results had been faxed to the LAPD laboratory. And from the standpoint of the defense being presented in this case with respect to the motive of the Los Angeles Police Department in terms of a motive to plant evidence, in respect to the integrity with which the evidence was handled, the fact that a leak emanated from the Los Angeles Police Department about DNA results before a DNA test had even been conducted evidences a good deal of confidence about those results that we believe would be informative for the jury in terms of resolving the issues that are directly presented by the defense in this case.
All right, that's pretty much covered, I think, in your motion filed August 1. All right, thank you, Mr. Ullman. Mr. Walsh, you would like to respond?
Thank you, Your Honor. I have, I guess, a three-part argument that I want to formulate. The first has to do with clarifying what it is that the defense is seeking here. And Dean Ullman suggested that this is not a pitches motion, and you said to agree. We use a lot of shorthand in criminal law, and I think the phrase pitches motion certainly is one of those shorthand phrases. The statutory scheme goes beyond a request for personnel records, which we most frequently see in police abuse cases or wrongful arrest cases. Penal Code Section 832.7 defines two types of records which are confidential. The first type of records are police personnel records. These are further defined in Penal Code Section 832.8. The second type of record, however, that Section 832.7 talks about are records of complaints maintained pursuant to Penal Code Section 832.5.
Which are citizens' complaints.
Well, these are complaints that the department has investigated. I don't think, I understand that the statute uses the word citizens, Your Honor, but I don't think the word citizens should be viewed as anything more than a descriptive word. I don't think it is intended by the legislature to have a limiting meaning.
Are you suggesting that if there wasn't internal investigations, that it was based upon some outside party or an internal request from the Los Angeles Police Department to investigate the accusations that were made?
I suggest that it doesn't make any difference, Your Honor, because initially the legislature commands police departments to set up mechanisms for receiving and investigating citizen complaints. And that's Penal Code Section 832.5. I don't know what the legislature had in mind when they used the word citizen. I'm quite clear, for one thing, that they didn't mean to preclude non-citizen aliens from being able to have their complaints about police misconduct heard.
No, but I think it is clear, at least in my reading, that is a complaint made by somebody outside of the police department.
Well, the reason why I don't agree with that, Your Honor, is that the legislature, in enacting Section 832.5, was attempting to deal with the issue which had arisen previously and which was addressed in the Pitchess decision regarding police department destruction of records of investigations. And they were attempting to balance the need of the police department to maintain some confidentiality in its records with the public's need to have access upon a sufficient showing. And I do not think that that difference turns on whether the investigation stemmed from a complaint made by an insider or a complaint made by an outsider, because the social importance of having the confidentiality of those reports and at the same time granting access upon a sufficient showing is identical, whether it be an outsider complaining about police misconduct or an insider complaining about police misconduct. I have been representing internal affairs for many years, and I can represent to the court that a great number of complaints regarding police misconduct originate from police officers. As a matter of fact, Los Angeles police officers are under an affirmative duty to report to their superiors any instances of misconduct or abuse which they see. And these are then investigated pursuant to the methods that the police department set up under the direction of the legislature in Section 832.5. When the legislature said in Section 832.7 that those documents were confidential, I think they had in mind that they were protecting the interests of the police department in maintaining confidentiality of any type of internal investigation of misconduct. And I think that's what the analysis should turn upon. When the Los Angeles Police Department established its procedures, it decided to include complaints, whatever their source, in this same general umbrella of coverage that's set forth in the declaration submitted by the police department by Commander Davis. The police department has traditionally insisted that these records be considered under the rubric of Evidence Code Section 1043. This is not a particularly onerous demand to place upon criminal defendants or plaintiffs in civil suits. All that is required to obtain exactly the result that Dean Ullman is asking for is that they complied with the procedural requirements of Section 1043, a noticed motion, a declaration laying out materiality, identification of the officers whose records are being sought, and then leave it to the judge to make a determination of whether the materiality has been met and whether the other procedures have been met. I don't know whether they can do that. I've heard Dean Ullman express statements today as to why these matters are material. They were never incorporated in any sort of affidavit. The affidavit that was submitted with the subpoena duces taken is certainly insufficient to justify intrusion into confidential records. It's merely a boilerplate statement. I don't think that it's asking too much of this team of highly experienced and competent defense attorneys to simply comply with the legislature's directive. These documents are privileged. Now, the second part of my argument really is derivative of the first. I'm not clear what it is that the defense is requesting. I was given the subpoena duces taken for the Internal Affairs report, and I responded to that in my motion to quash. I'm aware that there was a motion filed with the prosecution. A copy was handed to me, but it was not served to the police department, and certainly not directed at the police department. Dean Ullman today said that the SDT is basically mooted out, and yet his concluding statements, he suggested that nonetheless he thinks that report should go before Judge Ito for an in-camera review. Frankly, I don't care whether Judge Ito reviews some or all of the report. My clients, however, believe that the defendant should be held to the letter of the law. If they want to review these, they should meet the requirements set up by the legislature for reviewing confidential documents. They have done it in the past. There have been many other motions before this court, decided by this court, in which the defense has done precisely that. We have reviewed peace officer personnel records. We have reviewed, by means of a Pitchess motion, an investigation into allegations that one of the witnesses in the lawsuit, in the prosecution, a police officer, had made references to the deceased that suggested that he had more knowledge of her than he would in the normal course of affairs. All of these were done under the rubric of Pitchess and under the guidance of Section 1043. I don't understand why we have deviated from that at this point, and I would ask the court to rule that the defense should meet the 1043 procedural requirements.
Which, of course, one of which is a 15-day notice, which means we delay the proceedings.
The last time we were in here, Your Honor, in February, I was willing to waive that, and we got the motion in 2 days. I'm not trying to to make this trial last any longer than it's already lasted, but I haven't seen a declaration of materiality that I could address to decide whether the confidentiality of these records should be overcome. I don't understand, perhaps because I'm not fully a part of this trial, but only a very peripheral member, what the materiality is between the mere suggestion that a Los Angeles police employee is responsible for leaking information to the press in any relevant issue in this. It may very well be there, but it's not something that's clear to me, and I can't stand here and argue it without having it laid out for me. My clients are entitled to have a lawyer who can address these issues, and I can't do that. I don't understand how it is that the defense sees this as a relevant matter. In terms of the potentially exculpatory nature of anything contained in this report, the police department is certainly aware of its constitutional obligation to disclose exculpatory information to the prosecution so that it can be turned over to the defense, and the police department has never hesitated to do that. I'm not making any representation about what is or is not in the report, but that's really not at issue. This is not a motion to obtain potentially exculpatory evidence, and it doesn't come into play. The bottom line, Dean Ullman said, is the defendant's right to a fair trial. Fairness is the process that we're looking for here, but that fairness applies equally well to the police officers and other department personnel whose records are being sought as part of this internal investigation. And I would ask the court to require the defense to comply with the requirements of the statute. Thank you.
I'm not going to let you get away from the microphone that quick. So in essence, what you're saying is if they conform with what you believe the requirements of the penal code and the evidence code, then you will comply by bringing those records in for an in-camera review if it falls within 1043 and 1045 of the evidence code.
I'm not trying to say I won't comply at all. I have the custodian of records here right now if it's ordered that we have an in-camera review. But my point is that this is a two-step process, and the first step is that the judge is required to make a determination of materiality based upon an affidavit, and I'm entitled to challenge that once I've seen it. I haven't seen that yet.
Okay, that's assuming that it falls within the 832.5 and .7 penal code sections, that it is a citizen's complaint, and we can argue and debate whether or not this is a citizen's complaint, and whether then procedurally we have to go through what is required under 1043.
Well, I'm over here in response to the subpoena ducis tecum, as is the custodian of records, and that's basically all that I'm addressing, and that subpoena is clearly seeking the very type of report that's identified by Section 832.5. There is also a motion that's in front of you directed to the prosecution, asking them to produce records which they don't have, and which, if they were to ask the police department to provide to them, very likely the police department would say no. That would be backdooring the requirements of Evidence Code Section 1043. Tell the defense to make a pitches motion. And I do not feel that the police department was properly put on notice that this motion was addressed to them by it being handed to me in court. It's not addressed to the police department, it's addressed to the prosecution. The police department relies on the provisions of Section 1043, which says they are entitled to separate notice. They haven't received that notice. But I'm not trying to stonewall anyone. I think it's important that these arguments be made and that the law be adhered to. If you decide otherwise, as I said, I have these records here. We are ready for an in-camera review. But I do not think it should be called for on the record before this court.
All right, thank you.
All right,
Mr. Ullman?
Very briefly, Your Honor, I don't think there's much question but that the substance of everything that 1043 requires is in our moving papers. What is missing, however, is the identification of any particular officer, because that's not what we are seeking. And I think that goes to the heart of why what we're pursuing is not a pitches motion. A pitches motion is directed to personnel records of a particular named officer. Now, we could put a list together, and if we want to play guessing games, of every officer we think that Internal Affairs might have talked to in the course of this investigation.
Let me stop you there, unless I'm misinterpreted what Mr. Walsh has said. He's not arguing that point. The point he's arguing, technically you have not conformed with 1043 and its requirements, but specifically it's the materiality of the subject matter that you have requested. And 1043 does require an affidavit, which is not before me. It is merely a motion, and I don't stand on form over substance. If it was given to the district attorney, I presume that he passed it on to Mr. Walsh. If that's incorrect, please inform me.
No, I was given a copy of it by the defense, Your Honor.
All right. By the defense.
By the defense.
All right. So, it may not be technically the appropriate notice, but at least you were so informed. The question then becomes, is it material?
Well,
And have you reached that threshold to where then Judge Ito should have an in-camera hearing to determine what should or should not be turned over?
Well, the materiality is established by the very nature of the investigation that was being conducted. It was an investigation into the source of leaks of information in this very case. In fact, Your Honor was inquiring whether this was a citizen complaint. The complainant was the judge presiding in this trial. It was Judge Ito who initiated the request for some sort of internal investigation by the LAPD as to where these leaks were coming from in frustration. Experienced by all of the counsel in this case of picking up the morning newspaper and reading about lab results that we hadn't even seen yet. And Judge Ito took the extraordinary step of ordering that all of those results should no longer go to the Los Angeles Police Department. They should come directly to the court and then be distributed to counsel. So this is not a personnel complaint with respect to any individual officer of the Los Angeles Police Department. It is an investigation into circumstances that relate directly to this case and to issues that we are litigating in this case.
Well, that's the question. What is the material issue? The fact that Judge Ito was frustrated because things were being reported at a time, at least as I recall, a time that the jury was attempting to be selected, obviously is quite frustrating. And I'm sure that's the reason he asked for the investigation. But as to it being a material issue that is being presented to the trier of fact or before this court, that is the issue of materiality.
Okay. Well, it becomes a material issue in the context of the defense being presented in this case that evidence was compromised in the way that it was handled by the Los Angeles Police Department. And the fact that officers of the Los Angeles Police Department were leaking test results before the tests had even been conducted is highly material in terms of the trier of fact resolving that issue with respect to the integrity of the handling of the evidence in this case. So it goes directly to the whole chain of custody issue, to the issue of whether there was possible tampering with the evidence, to the issue of the motivation of the Los Angeles Police Department and the way it conducted the investigation of this case. Those are the issues we are litigating in this defense, and we're calling the same witnesses, we believe, that were interviewed. And of course, we don't know that. We haven't seen the report, but we believe, and we have testimony already from Michelle Kessler in a 402 hearing conducted by Judge Ito that she was interviewed by officers of the Internal Affairs Division in the course of an internal investigation. So we know this investigation took place. We know of at least one witness who was questioned. There may be others. I believe Matheson also testified that he had spoken to officers. So it is not seeking personnel records. It is seeking an internal affairs investigation. And I think where we part company, essentially, is that they are reading the statutes and the evidence code sections as some sort of privilege for internal affairs investigations. And that's not what the statute or the evidence code provisions are talking about. They're talking about the protection of personnel records with respect to citizen complaints. We're talking about something else, and we don't believe that the privilege created by the statute or the evidence code extends to any broad shield that can be erected around anything that internal affairs does, regardless of its materiality or relevance to an ongoing criminal prosecution.
All right. Mr. Darden, I see you either getting antsy or you want to address the court.
Both, Your Honor.
All right.
Good afternoon, sir. Your Honor, with the court here from Deputy DA Hank Goldberg on the issue of whether or not the information sought is relevant and material.
Yes? Mr. Goldberg?
Thank you, Your Honor.
Good afternoon.
I wanted to primarily address the issue of materiality, Your Honor, but before I got into that, I just wanted to say a few words about the appropriate discovery vehicle that's previously been discussed by counsel.
Well, let me stop you. And I seem to think that we keep getting off the track, or I don't understand where we're going. Mr. Walsh led me to believe that the issue really before me is it material. If it is material, then he will, in essence, forego some of the other formalities of discovery, since he's prepared to address that if the court allows an in-camera hearing. Mr. Ullman says it's material because the judge requested it and it pertains to the defense. We all get back to the same issue, at least as my understanding. Is it material to the sense that the court should grant an in-camera hearing to determine whether there is discoverable statements made by a potential witness in this case, which should be used in preparing examination of that witness?
I agree with the court that does seem to be the primary issue, but if I understood what Mr. Walsh said, and I'm sure he'll correct me if I'm wrong, one of the reasons that he wants compliance with the so-called pitches procedures is that he would like a declaration from the defense so that he could determine whether or not it was material and fully understand what their argument is or what their facts are to support the allegation that this does have some materiality.
Is this the same issue that's presented to Judge Ito in the shield, the reporter's shield, as to whether it's material, to whether or not that shield should be pierced for the benefit of the defendant's right to a fair trial, as weighed against the reporter's right to protect sources?
Yes, Your Honor. And
So are you not asking me, or all of you not asking me, the decision that he has to make in that particular
well, that's what I
decision?
think, Your Honor. And there's also a third context in which it comes up, and that's the people have filed a motion to preclude the defense from cross-examining Michelle Kessler about the subjects of the leaks. And the grounds that we've stated in precluding that cross-examination is lack of materiality. So it actually has three potential impacts in this trial. And in all due respect to the court, that's why I was a little bit confused as to how the court could decide the issue of materiality, given that that really is at the center of three distinct issues that are before Judge Ito, and plays a key role in terms of the overall issues in this case and what is or is not at issue in this case. So I don't know how Your Honor wants to deal with that problem.
Well, I'm somewhat disadvantaged. I don't know all the facts and the circumstances that have been presented, nor the previous arguments. If we are down to that issue, and if everybody agrees that that issue is before Judge Ito, at least in two other circumstances, that I am prepared to allow him to make the decision as to whether or not it is material. If it then is material, if he rules that the subject is relevant, it is a material issue that should be presented, then I assume, strike that, then it would be the court's intended order to allow an in-camera review of the internal investigations reports dealing with witnesses' statements. If he rules it is not material, then this all becomes moot, and the intended ruling of this court is that it would not be discoverable. Now, Mr. Walsh, you want to respond?
I want to briefly agree with what Mr. Goldberg said and clarify the police department's position. We do believe that the basic issue is materiality. I don't know whether it's the same question of materiality involved in the reporter's shield law, involved in the prosecution motion that Mr. Goldberg referred to, but the question is materiality. However, the police department wants to insist on its 1043 right to have that materiality laid out in a declaration, an affidavit, not by representations of counsel.
All right, let me stop you there, Mr. Ullman. I think they are technically have a right to have that affidavit or declaration. When can that be prepared and served upon Mr. Walsh or the LA Police Department?
We can take the material that's in our moving papers and put it in a declaration and file it tomorrow. But again, that is assuming that this motion is governed by the pitches requirements. I think Your Honor's on the right track with respect to the determination of materiality. In fact, Section 1045 of the Evidence Code, which honors the right of the defendant to material that is relevant to the subject matter in the pending litigation, provides that in determining relevance, the court shall examine the information in chambers in conformity with Section 915. So what's initially required to get production of the report is simply a prima facie showing of materiality, like in a discovery motion, that it has potential relevance. And then once it's produced, the court makes that determination in the course of its in-camera inspection. There's certainly more than enough to show the prima facie materiality in our moving papers, and we can put that in declaration form, although we don't believe that's required because it's not a pitches motion.
Well, form, once again, I think it's form over substance, but I'm going to require that of the defense to present that to Mr. Walsh or a representative of the Los Angeles Police Department. I think the court always has to determine whether something is material before it should be turned over by way of discovery, whether or not it falls within the four corners of 1043 and 1045 and the other sections that we have previously mentioned. I think at that point, when Judge Ito has an opportunity to review the affidavit or declaration, then I think it would be appropriate, because he's far more familiar than I, to make the determination as to whether or not it's material. And if necessary, I will then, based upon his decision, make a ruling whether or not there should be an in-camera proceedings, for which I understand all parties have agreed that he will hold. He will review whatever is available and then make the decision as to what is discoverable or not. I will only make the order if he makes a determination it's material. Now, does anybody want to add anything at this point, or we'll leave it at that?
Just briefly in that regard.
Mr. Cox.
Good afternoon, Your Honor.
Good afternoon.
In that regard, Your Honor, it's a scheduling matter. We certainly appreciate what Your Honor has indicated. We seem to be on the right track here. We can certainly have that declaration tomorrow morning. As a matter of importance, however, we're at that stage in the trial where these may very well be the next witnesses. I've represented to Judge Ito this afternoon that we need a ruling on this along with some other motions he's working on that will also be important. We don't have other witnesses at this point in the trial, so we need to get this done and need your availability perhaps tomorrow morning, because we want to resolve this, get this to Judge Ito. He can make his judgment regarding materiality, If you then rule or make an order, he can then review the documents and then make a determination, because these will be our next witnesses. We need time to look at those reports before calling those individuals.
All right, well, I'm available anytime after 7 tomorrow morning. I think you need to make some arrangements with Mr. Walsh and Mr. Darden and whoever else, what time those will be presented, and then present it also to Judge Ito and give him the opportunity to review them.
I think we're also entitled to make some argument about them, which means we need to have time to review and possibly prepare points and authorities in response to it.
Well, Mr. Walsh, I understand your position, but I suspect this is not coming totally as a surprise to you.
Nor is it coming totally as a surprise to the defense either, Your Honor. They have had, I believe, 10 months to prepare this motion. They have had 6 days since I filed my motion to quash the SDT, where I put them on notice that I was claiming that this was covered by the provisions of Section 1043. They're waiting until this afternoon, and now they're saying, gee, they have to have an expedited ruling on it. I think that the police department is entitled to have its opportunity to be heard in this matter. The legislature has set out the procedures. I'm not insisting on 15 days, but I don't want a 5-minute or 2-hour turnaround.
All right, what time, Mr. Cochran, will you have that declaration before the court?
And I'm sure we can have it here by 8:30 tomorrow morning. And
Okay.
we would expedite it, and we certainly are dragging our feet because, Mr.
No,
Coleman, you understand.
Let's not make
Right.
accusations.
Right.
It
Okay.
accomplishes nothing. Let's
Fine.
try to expedite it,
8:30?
giving both sides an opportunity to a full hearing and to litigate the issues. You'll have it by 8:30. Is there a time set tomorrow for the return of the jury?
We've not reached, I think the jury may still be somewhere upstairs now, I believe, Your Honor. They've not been released yet, so the court still can do that. We perhaps need to speak with Judge Ito after this is over, all parties.
All right, why don't we stand in recess at this particular time. Let me have an opportunity to confer with Judge Ito, and then if necessary with counsel in regards to when we can have an opportunity for not only Mr. Walsh, but for he to review the declaration and make a determination, and if necessary, hear from counsel. And I will make myself available tomorrow at any time so we can hopefully resolve this to everybody's satisfaction. All right, let's stand in recess then.
All right, back on the record. I understand we need to settle some scheduling matters. Counsel?
Yes, Your Honor. May I address
Yes.
Just briefly, as I understand it, Judge Reed has listened to the arguments of counsel and has basically concluded that if the defense were to proffer a declaration regarding materiality, which I've represented, we would have here tomorrow at 8:30, he would then ask that Your Honor consider this declaration of materiality. He would then, if you found it material, which we trust you will, he would then make an order turning over certain reports conducted by Internal Affairs. And we were then in a kind of a scheduling quandary. I indicated to him that, as I told you, these are our next witnesses. We need to get an idea of scheduling. We're all available, but we need time to go through the reports, synthesize them, and then get ready for the next witnesses. And the court is aware who those witnesses are.
You know, this actually compounds the issues regarding the Bosco
Yes.
issue.
And that's the other part.
Because, I mean, this broadens the scope of alternative sources, which is really where we're going
Yes.
with all of this. So you're saying that I need to make an initial finding of materiality first
We think so.
before I even get to the balancing test, the other balancing tests that are suggested in Delaney. Is that?
I think it's a threshold finding, really, Your Honor, that Judge Reed, I mean, we would all agree you're in a better position than Judge Reed being at a disadvantage. You need to make that particular finding. This issue can somewhat stand on its own, but we wanted, as Mr. Ullman indicated to you, we think this issue should proceed before your other issues because it will assist you, hopefully.
Mm-hmm. Yeah, I see the point.
Judge, Your Honor.
All right.
I think where we're at is a threshold determination of materiality needs to be based on this declaration, but the issue of relevancy is part of the in-camera review under Section 1045. So all we're talking about is kind of a prima facie showing of materiality at this point to get the records turned over. At that point, Your Honor reviews them. We believe that review can encompass a determination of whether there are witness statements that the defense is entitled to, whether there is Brady material in the report, and whether this alternative source has been exhausted in terms of the newsperson's shield law determination that Your Honor is also considering.
All right. Mr. Walsh?
One question in terms of scheduling that was left unanswered is to what extent the city and the police department will have an opportunity to review the declaration and submit some sort of response regarding our view of its materiality.
How about if we do this? How about if I direct you and the representative of the defense handling this matter to be present here tomorrow morning at 8:30?
I have a conflict, Your Honor. I
Okay.
have a civil court appearance. I may be able to have a different attorney cover this or that, but at this moment I'll have to work that out. All right, why don't we, let's do the 8:30, and I'm not
8:30.
sure it will be me.
And then on the record at 9 o'clock, I'll allow you to make any representations or any argument in contravention to the declaration of materiality,
All right.
rather than require a written response. So I think that will expedite matters. And I will be prepared tomorrow morning at 9 o'clock after I hear the arguments to rule on whether or not there's been a prima facie showing of materiality.
And would you then do the in-camera if you made that determination?
Yes.
So I would have the
Yes.
custodian present for that. Very well.
Have them available within a short period of time on call.
All right.
All right. Okay, what else do we have left?
Well, we have one other motion, but then that, based upon that, Your Honor, I suppose, just as a matter, could the court give me some inkling of then what Your Honor's pleasure is going to be regarding the ruling that may also follow this ruling, and because we'll know then better who our next witnesses are going to be, because that's the issue.
Well, here's the problem, Mr. Cochran. Once I make a finding of materiality, assuming that that occurs, then Delaney sets out 4 different criteria that I then have to contemplate and balance. I won't know what those criteria are unless and until I conduct the in-camera hearing with IAD, or if that avenue is foreclosed, and then that becomes a moot issue, and then it's a different equation. Then, assuming we get past all of that, and let's assume that I issue an order directing Mr. Bosco to testify, then they are going to request a stay, as they've indicated that they're going to challenge that. So, and it would be my preference to, allow them some time to take whatever appellate remedies that they have available to them. So my guess is that we ought to probably prepare to go forward with witnesses in the next day or two other than these people. Because let's assume that all the cards fall in your favor, and we do have, and I do require the news media people to testify, they are going to request stays and go to the Court of Appeal. And they won't be available till at the earliest the end of the week, or perhaps the beginning of next week.
All right, given that thought, Your Honor, we will then...
And the prosecution has all along said they're going to raise 352 objections to all of this as being speculative unless there is a very clear connection between this and that.
We think we can make that, but we
So-
will, out of an abundance of precaution...
So my suggestion to you is that you be prepared to go forward with witnesses other than this circle of witnesses.
by Thursday, is that what you're saying to me?
How about tomorrow?
Well, we have some work tomorrow morning, certainly.
How about tomorrow afternoon?
Let me see if... I hope we can do that.
It would thrill me to death if I had the morning to work on this
Oh,
stuff.
that'll be fine. And as far as the jury, then let us then see where we are, and let's try to be ready tomorrow afternoon with some witnesses. We don't want to delay the trial, if at all possible. We'd like to go in the order we've talked about, but I understand the procedural problems.
Even if I ruled in your favor today,
Yes.
we still wouldn't have live witnesses really available till next week, my guess. And Dean Allman's nodding that he thinks that's probably true.
We probably can, well, we'll work that out, We'll try to have some witnesses for tomorrow afternoon, hopefully.
All right, and let Mr. Darden and Ms. Clark know.
We can proceed with
All right, Mr. Walsh, thank you very much, sir. See you tomorrow morning.
Witness other than Dr. Bodden,
I assume the Gretchen Stockdale matter will resolve this afternoon. My recollection is that counsel contacted the court, or the court contacted counsel, and he and she are available this afternoon, is my understanding. She's en route.
Okay, I heard she should be here 2:30, that's fine.
Well, she may be still stuck at the metal detector.
we could have an opportunity to confer with her, and we'll then proceed.
I'm assuming that we can resolve this without a full hearing once she's here.
I thought the court had wanted testimony to resolve what,
No, well, as I indicated to you, there's a factual dispute. One side says one thing, the other side says something else. If she's here, she can tell us one way or the other.
right. I assumed you want that in the blue chair, but
Well, if she comes in with a tape recording and says, here it is,
happy day. Okay.
you never know. All right, so my proposal is for this afternoon then that we release the jury and that we stand in recess until the arrival of Ms. Stockdale and her counsel.
Maybe first one.
Sure. All right, thank you, counsel. We'll stand in recess then until Ms. Stockdale and her counsel arrive, and we'll conclude with that hearing today. All right. In the Simpson matter, all parties are again present. The jury is not present. I understand we have Ms. Stockdale available and her counsel. Is that correct? All right, and who are the counsel appearing with Ms. Stockdale?
Good afternoon, Your Honor. Tom Rowland and John Schuster.
All right, good afternoon, counsel. You want to state and spell your names for the court report, please?
Nolan, Nolan,
And John Schuster, Schuster.
All right, counsel, what we're here for is a discovery proceeding to determine the whereabouts, history, etc., of a certain telephone answering machine, tape recording. Have you conferred with your client?
We have, Your Honor. We also have conferred with both the District Attorney's Office and Defense Counsel and explained the situation, and Ms. Stockdale is prepared to testify this afternoon.
All right, then we'll proceed.
Thank you.
And counsel, if you feel it's necessary to consult with your client anytime during the examination, feel free to ask leave of the court for that purpose.
Thank you. We expect it not to be necessary.
All right.
Thank you.
Ms. Clark.
Thank you, Your Honor. People call Gretchen Stockdale.
All right, Ms. Stockdale. All right, Ms. Stockdale, face the clerk, please.
Raise your right hand, please. Do you solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? Yes, I will. Please have a seat and witness stand and state and spell your first and last names for the record.
My name is Gretchen, Gretchen, Stockdale, Stockdale.
Ms. Clark.
Thank you, Your Honor. Good afternoon, Ms. Stockdale.
Good afternoon, Ms. Clark.
Thanks for coming in.
Sure.
Were you acquainted with the defendant back in 1994, ma'am?
Yes.
And as of June 12, 1994, had you been dating him for some period of time?
No, I wouldn't characterize it as dating.
When had you met?
Oh, in 1988, casually at a charity event.
And then had you seen him again after that?
Yeah, we ran into each other several times over the years.
And at what point did you at some point begin a dating relationship?
Like I said, I wouldn't characterize our relationship as dating. We had a good communicative friendship. And in 1993, around the fall, I contacted him to actually ask his advice on an investment issue.
Okay, what kind of contact did you have? Did you ever meet for dinner?
Prior to...
Object is irrelevant
Overruled.
for this issue.
Overruled.
Could you be more specific? With,
Yes.
Are you...
Yes. Between 1988 and 1994, did you ever meet him for dinner?
No, actually,
Counsel, all I'm really interested in is the flavor, the nature of the relationship, so let's not go too far with this.
Okay.
All right.
All right. Were there any intimate dinners that you had?
No.
During the scope of time you saw each other?
No,
Did you ever see each other in person?
yes, as I said, I ran into him several times on different occasions. NFL functions, charity events. I actually did run into him into a restaurant one time. And he was on a date with Paula, and I joined them briefly.
Okay. Then, at some point in the year of 1994, did that relationship become more intimate?
No.
Never at any point?
Well, yeah, I think our communication increased around 93, as I stated, around the time when I called and asked him for some advice.
And that was business advice?
Yes.
All right. And then did you continue then to have regular phone conversations after that point in 1993?
Yes, I would say so.
And were those conversations all regarding business?
No.
They became more personal?
Yes, we developed a friendship.
And did you discuss with him the nature of his relationship with Paula Barbieri?
Objection, Your Honor, irrelevant.
Sustained.
Okay. Did you discuss with him the nature of his relationship with Nicole Brown Simpson?
Same objection.
Overruled.
Yes, periodically.
Okay. And when did you begin to have those conversations concerning Nicole with the defendant?
Around the fall of 93.
And did you continue to have those conversations with him through 1994?
Yes.
When you had those conversations with him about Nicole, was that in person or on the telephone?
Both.
And when you had those conversations with him in person, where did they take place?
Oh, a number of different places, at his home, at my home, at a restaurant.
Okay. How many times would you say in the year of 1994 did you have conversations with him about Nicole in his home on Rockingham?
I'm not really sure. I couldn't give you a number.
Can you give me an estimate? Like
How many times we spoke about Nicole,
in 1994?
specifically at his home?
Yeah.
Is that what you're asking me? Oh, 3 times.
And when in 1994 was it that you had those conversations about her in his home?
Counsel, I think our focus here is the tape, though. That's what we're interested in, correct?
Yes, Ron.
All right.
All right. Can you tell us how many times you visited him in his home in 1994?
Counsel, let's move on to the tape.
Okay. By June the 12th, 1994, had you formed a more intimate relationship with him in terms of personal discussions and involvement?
In terms of communication, yes.
Okay. Had he made any overtures to you about becoming his girlfriend?
No.
Oral answer will stand. Let's move on to the tape and the whereabouts of the tape, please.
All right. On June the 12th, 1994, at some point, did you leave your home?
Yes.
And did you come back and retrieve a message?
Not on the 12th, no.
Okay. When did you retrieve that message?
I retrieved a message on the 13th, but not from my home.
All right. Did you have an answering machine or a message service?
Yes, it's an answering service, a telephonic answering service.
Can you tell us how that works?
It's my voice on the machine, and you can leave a private message on that machine. Then I call in and enter a code and retrieve my messages.
Okay. Is that like voicemail?
Yes.
All right. And did you retrieve some voicemail on June the 13th?
Yes.
And was that message from the defendant?
Yes.
Did you have an accurate recording of the time on your voicemail?
It states the time on my voicemail, what time the message comes in.
Okay. And do you know, if you know, as of June the 12th, 1994, in the evening hours, was the time stamp on your voicemail accurate?
As far as I know, yes.
Okay. You had not made an independent check?
No.
All right. When you retrieved the message, did it indicate that the message from the defendant came in at 7:35 p.m. on the night of June the 12th?
Yes, it did.
And I'm going to read to you a quote from the New York Daily News. I'm going to ask you to tell me whether or not this seems to replicate the message that you recall being left for you, okay?
Okay.
On the night of June the 12th at 7:35 p.m., okay?
Okay.
Quote, "Hey, Gretchen, sweetheart, it's Orenthal James, who is finally at a place in his life where he is like totally unattached with everybody. Ha ha. And in any event, I've got a Sunday evening. I guess I'm catching a red eye at midnight or something to Chicago, but I'll be back Monday night. If you leave me a message, leave it on 310 and then a number, and then that's 310 and then the number repeated again." Do you recall what I've just stated to you as being the message left for you by the defendant on the night of June the 12th, 1994?
I can't recall verbatim, but it appears close, yes.
It sounds right?
Yes.
If I showed you this and let you read it, would that help you to state whether or not this was an accurate rendition of the message you got?
You could show it to me, but again, I haven't heard it for quite some time, so I don't know if word for word is correct, but it's basically what I remember.
Okay. Okay, I'll let you look at it in a minute and see if that helped you anymore.
Okay.
But then you picked up that message on June the 13th, is that right?
That's correct.
From your voicemail?
Yes.
Did you preserve that message in some manner?
Yes, I did.
And how did you do that?
Just by pressing the number that indicates save on my machine.
And you saved the message on, was that a regular tape or a microcassette?
Well, I'm not sure what they have at the answering service. It's whatever they have in their building.
Okay.
I'm not sure how they use it. Maybe computer or disk.
Okay. Now, the statement that he makes in here, that he said he's finally in a place in his life where he's like totally unattached and he said he'd love to, evening, I guess I'm catching a red eye, I'd like to get together Monday night. Was this the first time that he had made such a statement to you about being free and available?
Objection irrelevant.
Sustained. I'm interested in where the tape is.
All right, you pressed the button save.
Yes.
Then what did you do? Did you ever retrieve that tape physically?
At a later date, I asked for a copy.
Okay. From your answering service?
Yes.
And they gave it to you?
They mailed it to me.
And was it a micro cassette or a regular cassette?
It was on a regular size cassette.
Okay, and then when was it that you got that cassette physically in your possession?
That one I received on, I don't know, a week or so after the message was left.
So that would have been the 19th of
Or
June?
around there, 20th.
And when you got that cassette in your physical custody, what did you do with it?
Put it away.
In
Just in my closet, I think.
Okay. At some point in time, did you have a conversation with a defense investigator by the name of William Pavlik?
Yes.
And when was it that you had that conversation with him?
It was sometime September, October, I can't remember clearly, of that year.
And do you recall having a conversation with a DA investigator by the name of Dana Thompson on June the 21st, 1995?
Yes.
And do you recall telling him that you turned over that tape to William Pavlik, the defense investigator, in September of 1994?
Yes.
And does that seem, to the best of your recollection at this time, an accurate time for when you gave Mr. Pavlik that tape?
Yes.
Okay. And then when you had the conversation with Mr. Pavlik, you, at that time, physically gave him possession of that tape?
Yes.
And did you tell him what was contained on the tape?
Yes.
Did he tell you what he intended to do with it?
Yes.
What did he tell you?
That he would take it and listen to it and pass it on to other members of the defense.
Did he tell you whether or not he intended to present it? They intended to present it in evidence.
At that time, he didn't say one way or the other what he planned to do with it.
At that time, did he tell you whether or not he thought that they would call you as a witness for the defense?
No, he didn't.
You had no conversation about that at all?
No.
I'm sorry?
We didn't.
Did you expect to be called as a witness for the defense?
No.
Okay. Did you expect
Are there any copies of this tape anywhere? Did you make any copies before you gave it to Mr. Pavlik?
Yes, there was another copy made.
All right, how did you do that?
I held up a cassette recorder to the telephone, the actual telephone.
And what happened to that copy?
That has been taped over.
When did you notice that it had been, when did you realize or discover that it had been taped over?
Well, I didn't realize it. I did it several months ago.
All right, what is the name of the telephone answering company that provides the service for you?
Prestige voicemail.
And where are they located?
Lomita.
Ms. Clark, anything else?
Yes, thank you, Your Honor. Can you tell us, ma'am, how many times you visited Mr. Simpson in the jail?
Sustained.
Can you tell us how many times you visited the defendant in jail since June 21st, 1995?
Overruled.
I haven't.
You had no visits?
No.
Wait. Let's move on to something else. It has to do with the location of the tape, where it went, who's got it.
Do you
Was
recall?
this tape ever returned to you by Mr. Pavlik?
No, it wasn't.
All right.
Did you play the tape for Mr. Pavlik?
No, I didn't. He brought a tape recorder along, but it was a micro cassette, and as I stated, it was on a regular size tape recorder, so he took it with him.
Now, you were interviewed by a reporter for the New York Daily News, correct?
That's incorrect.
You were not interviewed?
No, I was never interviewed.
You did not have any conversation then with Michelle Caruso of the Daily News?
Absolutely not.
Did you ever play that tape recording for anyone?
No, I certainly did not.
You didn't play it for Michelle Caruso of the Daily News?
No.
Did you play it for any of your friends?
No, I didn't.
Did you play it for any members of the defense team?
I didn't personally play it. I don't know what Mr. Pavlik did, but I didn't.
What about the why did you make the additional copy after you gave the first copy to Mr. Pavlik?
I didn't make it afterwards. I made it at the same time I requested the copy from the voicemail.
Okay, and why did you make that extra copy?
In case the one from the voicemail got lost or it didn't work or I didn't get it, I would still have one.
Okay, and you did not give that extra copy to Mr. Pavlik?
No.
Do you recall being when you were interviewed with Dana Thompson of the DA's office on June 21st, 1995? Do you recall telling him about that second copy? The copy you made yourself from the telephone?
No, he didn't ask me if there was a second copy.
Okay. Would you do me a favor, please, and review this statement here?
Okay.
That is a report of your conversation with Dana Thompson, and tell us if the information contained in that is accurate.
It's incorrect.
And in what respect is that?
The portion of the sentence that says, and gave him her only copy of the above tape. He just asked me if I gave a copy.
All right, and in this interview report, it states that you told him on June 21st, 1995, that you gave Mr. Pavlik the only copy of that tape in September of 1994. That's what it states here, is that correct?
That's what it states.
And your testimony now is that that's incorrect?
Correct, that's incorrect.
Okay. Now, do you also recall that you, through your lawyer, demanded a retraction of a portion of the story that was run in the New York Daily News concerning this tape?
Yes, that is why I initially retained legal counsel, is because I wanted formal papers filed demanding a retraction that I was trying to sell this tape.
Okay.
It's absolutely a false assertion.
Okay. And that portion of the article that asserted that you were trying to sell this tape was in fact retracted at your request, correct?
You bet it was.
Okay. And then, but the rest of the article, which details the quotation that I've read to you, you did not demand a retraction as to that, correct?
No, I didn't.
And I'm going to ask you to review what's highlighted here. It shows the date, the time, and the substance of the conversation that was recorded, and ask if that is correct and accurate to the best of your recollection.
It's close to what I remember.
And the court has already elicited the statement as to what the name of the service is?
You know, most of these voicemail systems are actually computer disks. Digital.
That seems to be an accurate rendition to you?
Yeah, as I said, I don't remember word for word
Okay.
what it said.
And then is your testimony... Can you remember at this time who it was that you asked at your answering service, the name of the person you spoke to when you asked for the copy of the tape?
Yes.
Shall we say that? Can you tell us?
His name is Bruce Humiston.
Can you spell the last name?
I'm speculating Humiston.
Okay, well, we'll look for something close. Did, when was it that it came to your attention that the other copy that you kept was no longer useful?
After I recorded over it. What,
And
you
when did
mean-
that happen?
Oh, several months ago. March, April.
March, April of this year?
Yes.
Okay. And did you, when you were recording over it, did you know that you were recording over it?
Yes.
Okay. You intentionally did that?
Yes, it was no longer any importance to me.
Okay. Did you check with anyone on the defense team before you did that to make sure that it would be okay to erase it, basically?
No.
Okay. Did you inform anyone on the defense team that you had done so?
No. Not at the time I did it.
When was the first time you informed anyone that you had erased that other copy?
The first time I told anyone,
Yeah.
when the issue arose in the New York Daily News when I was speaking with my lawyers.
Okay. And that was back in May of 1995?
Yes.
May I have a moment, Your Honor?
Mr. Allman?
Ms. Stockdale, the copy of the message that you made yourself, was that before or after you received the copy from your answering service?
Before I received the copy.
All right. So initially, you just held a tape recorder up to the telephone and made a copy yourself?
Yes.
All right. And then later, the answering service sent you another taped copy of the message?
That's correct.
Now, do you recall which of those two you gave to Mr. Pavlik?
I believe it was the one I received from the voicemail service.
All right. And the one you kept then was the one that you had made yourself?
Yes.
Now, you didn't tell Mr. Pavlik when you gave him a tape cassette that it was your only copy of the message, did you?
No, I didn't tell him it was my only copy.
And when you were interviewed by the district attorney in June of this year, you did not tell them that you gave Mr. Pavlik your only copy?
No, I didn't.
Right. Now, you gave the copy of the tape to Mr. Pavlik in September?
That's to the best of my recollection. That's what
And
I
the best of your recollection is that the copy that you kept was not erased until March or April?
Yes.
So then after you gave Mr. Pavlik a copy, you still had a copy for approximately 5 months?
Yes.
Now, did Mr. Pavlik at some time call and inform you that you were not going to be called as a witness by the defense?
Yes, he did.
Was that before or after you taped over your copy?
That was sometime before I...
All right, so you were aware then, when you taped over it in March or April, that the defense had decided not to call you as a witness?
That's correct.
And did you ever request that Mr. Pavlik return the copy of the tape that you had given to him?
No, I didn't.
Nothing further.
Ms. Clark?
In September, when you first met with Mr. Pavlik and gave him this tape, did you discuss the subject of how many copies there were with him?
I can't recall.
Do you recall him asking you if that was the only copy?
Yes, he did.
And do you recall what you told him?
I told him that no, it wasn't the only copy.
And did he ask you what you had done with the other copy?
No.
Did he ask you not to give it to anyone?
No.
Did he ask you to maintain it or keep it preserved in some fashion?
No.
Did he tell you what he intended to do with his?
No, he didn't. It's other than take it that day and pass it along.
And is it your testimony that you erased it in March or April because he told you you were not going to be called as a witness?
No, because he had told me a long time before that I taped over it because I needed a tape.
So it just happened that it was in March or April of 95?
Right.
Okay. Nothing further.
Ms. Stockdale, do you still have the tape, physically the tape itself that you taped over?
I believe I do. I've been looking for it.
You've been looking for it, but you haven't found it.
Yes.
All right, do you know how many times you've taped over that tape?
A couple times.
Makes it a little more difficult. All right, do you have any objection to if Prestige voicemail still has the original message on their information systems there? Do you have any objection to the parties getting a copy of that phone message?
No.
All right, do you have any idea how a New York newspaper wound up?
That's a mystery to me.
All right, thank you very much, Ms. Stockdale.
Thank you.
All right, Mr. Nolan, thank you.
Your Honor, with respect to the authorization to seek her messages from Prestige, that authority would only go to that one message?
That's correct.
Thank you.
All right, anything else, counsel?
In the event that there is further service process, Ms. Stockdale, counsel will accept service on her behalf.
We'll accept it. We'll accept service.
All right, thank you, counsel. Yes, at this point, I think we need to discuss also the 1054.7 issues with regards to this tape. All right. Ms. Clark, anything else you want to add to the record with regards to Ms. Stockdale?
Well, factually speaking, perhaps we have a conflict here, and maybe what we need to do is call Dana Thompson. Unless I don't know if it matters. Actually.
Well, the issue was whether or not Ms. Stockdale had a copy that was still available. She's indicated that she taped over the tape a number of times, so in all likelihood, it's not recoverable, except for perhaps by the NSA, and I don't think they're going to help us with this.
Fairly doubt it, Ron. And that was back in March or April of 95, before we could have known.
Right. Now, have you made inquiry of this phone voicemail service, whether or not their database still includes this? Because you've gotten authorization from her to get the original from the digital format.
This is the first we've heard of it, Your Honor, so we will do so.
All right.
So does the court want us to make that effort to get that before we resume with argument on this issue?
The defense previously, under 1054.7, filed affidavits regarding this particular tape. And Mrs. Robertson will need to get that sealed package. All right. But I do think that you ought to, at this point, I'm going to direct you to contact the voicemail service and see if that database from that date is still available.
The people would make a motion then for those 1054.7 materials, though, to be discovered at this time as well.
All right, I'll take that matter under submission. All right, but I'm going to direct you to contact the voicemail system this afternoon, and Bruce Humiston was the name? Humiston.
And
All right.
then we'll revisit.
We'll see where we are at that point.
The 1054.7 submission, Your Honor, was to preserve the defendant's work product privilege. We don't believe that they're entitled to see that, but the only theory under which there's any duty at all to turn this over would not arise under 1054, but under the Meredith case.
That's right.
And that's whether we have foreclosed access by the prosecution by taking physical possession of...
Which is why I'm directing, I'm putting them on notice that that exists, that it's still in sealed condition. I'm directing them to go to the original source at this point.
Correct.
Right. We have no dispute about Meredith controlling on this issue.
Well, we contend Meredith doesn't apply because it's not inculpatory evidence and because we have not foreclosed access. So for both of those reasons.
All right.
All right.
Well, we already framed
Yeah.
this one for the court.
May become a non-issue later today.
Yeah.
All right, anything else we need to wrestle with this afternoon? All right, then we'll stand in recess until 9 o'clock tomorrow morning with regards to the IAD issue and finding materiality after the city attorney's office, after the defense files its declaration of materiality. Court will hear orally any argument that the city attorney's office has. I'll hear comment from the district attorney's office as well. And then I'll hopefully be able to make a ruling on the prima facie materiality issue at that point.
That's just SPIAD.
Right. Well, this is the whole issue, though. That's one small part of a larger issue. Because, I mean, that issue includes, Dr. Reeders, it includes McDonald. I mean, it's the whole issue of blood on the socks is what the issue is. And then I think the defense should be prepared to go forward with its next witness at 1 o'clock tomorrow afternoon. 1 o'clock. 1 o'clock tomorrow afternoon.
And we're going to do the best we can. We may not have enough to fill the entire afternoon if we don't get the Dr. Batten and I'm working on it as I can.
Well, make your best efforts.
I will.
All right. Anything else? All right, we'll stand in recess. Thank you, counsel.